Morning, everyone. I'm just waiting for the Department of Corrections to connect. Could the Department of Corrections turn on their camera? Thank you. All right, good morning. We are recommencing the proceedings in Burgess and Rogers. The appearances are as before, and the proceedings are taken before my Lord President, Sir Christopher Clark, and Justices of Appeal, Bell and Kay. My Lord President.
Right. Good morning, everybody. I'm sorry for the slight delay, which was attributable to internet problems. We have, I think, essentially two matters to deal with this morning. First is what we should do or not do in the light of the interview that the registrar has had with the foreperson of the jury. And the second is what is the relevance of the discussions that took place before the summing up and before the final speeches as to how matters were to be left to the jury, and in particular, what was or wasn't going to happen in respect of the hater direction. I think it's sensible to deal with these separately. So we'll start with the question about the interview with the foreperson of the jury. We have been discussing this matter amongst ourselves, and we incline to the view that we should ask the registrar to interview the juror who spoke to Mr. Daniels, as well as the foreperson, though we are open to submissions to the contrary. We don't believe that what the registrar did or what we propose involves a contempt of court, because she acted upon our direction, and it can't be a contempt to do that of the court, to do that which the court has directed should be done. But under this heading, a number of further questions arise. The first is, should we interview the juror who spoke to Mr. Daniels about what he said, which was to the effect that half the jury were minded to acquit and decided not to in order to avoid being sequestered overnight, which the foreperson of the jury in her evidence denies. So the first question is, should we interview the male juror who says this? The second question is, should that interview extend beyond asking him whether what he said to Mr. Daniels was correct, and should it extend at all to asking him to give any account of the jury's deliberations in the light of what the foreperson of the jury appears to have said about deciding the case without accepting the confession said to have been made by Mr. Rogers. And then I suppose there is then a potential further question as to whether, having interviewed her and having interviewed him, we should interview anybody else. That has the risk of creating an inquiry to up to 12 jurors, which doesn't seem appropriate. So those are the topics that under this heading we would like you to address and help us with. I don't know what order it is convenient to take it in. Doesn't matter a great deal. I suspect we ought to start with the appellants. And they can choose between themselves which one goes first.
Just before we begin, I wanted to introduce my pupil, Lorendi Simons, to the court.
Thank you.
Thank you.
Welcome. Somebody is saying something somewhere which I can't follow.
I believe that's Mr. Rogers. Are you trying to communicate to your counsel?
No, I was just trying to wonder, that I don't see everybody on the screen, but.
Well, on my end, I can assure you that everyone is here.
Okay.
Do you see your lawyer and the judges?
No, I don't see my lawyer. I just see you and the two judges up top in these small little screens, but, then I have them the full screen where I can see everybody like I did all last week. So I was just trying to get the officer to put everybody on.
Okay. Well, Ms. Mulligan spoke a moment ago. Did you hear her?
Yes, I saw her, yeah.
Okay, all right. As long as you can hear us, we'll try to get this logistics sorted out.
Okay.
All right.
Well, Ms. Mulligan, would you like to start?
Certainly I can. With respect to question number 1, the juror question, I have provided some written submissions. I'm certain that the short time frame that the court has probably had a chance to look at them.
We have.
And I mean, the upshot of it is that, of course, what the juror said, the foreperson said, was somewhat surprising. Not expected that she would say what she did. But having said that, it's a little bit difficult in my respectful submission to put the genie back in the lamp, as it were. She has, when we're talking about repudiation of an oath, if what she says is correct or could possibly be correct, that the jurors didn't give much weight at all, if any, to the confession evidence.
No, but I know how to get it, whereas you see everybody just screwed up. What's his name?
There, it's muted.
All right, Miss Mulligan, on my set you froze there, so I wonder whether you could just go back 30 seconds.
Sure. Given what she has said about not giving much weight, if any, to the confession evidence against Mr. Rogers, right. If that is so, or if it might reasonably be so, if there's a suspicion that that's what they did, it is just as much a repudiation of the oath as the jury pressure point. Because that means they decided the case not only based on no evidence against Mr. Rogers, but also contrary to the judge's instructions completely, that if they found they didn't accept the confession evidence, they were directed to acquit Mr. Rogers. So that's of concern. I think that I agree, and I've put in my submissions that the juror who spoke to Mr. Daniels should still be interviewed. At best, we got from the foreperson her perception of how she felt, but there is some indication of moaning and groaning about going to a hotel. And in light of what the juror said to Mr. Daniels, I think that point needs to be reviewed. I would not commend to the court that the second juror should be asked anything further about their deliberations. There has to be a balance. And obviously the secrecy of the jury deliberations is an important principle that should be upheld so far as possible save and accept where it needs to be breached to prevent a miscarriage of justice. In this case, we have enough. If one looks at the decision that I provided from Smith and State of Western Australia, and if you take a similar approach, there is enough of a suspicion cast over the verdict on the basis of what the foreperson has said, that alone, in my respectful submission, ought to be enough to require a new trial at the very least.
Yes.
To go further and start inquiring into the 12 jurors doesn't strike the balance that is necessary. I have read the cases, certainly going back, some of them quite dated, that speak about the jury's deliberations being sacrosanct. And that the principle or the purpose for that is to ensure that they have their full and frank discussions and they don't feel that, you know, anyone's going to be looking over their shoulders. But ultimately, the purpose is so that justice can be done, so that they can do justice. What we have here is a clear indication that justice wasn't done. And there is no way for the prosecution or the court to call evidence to, I guess, to convince the court at this stage, in my respectful submission, that the verdict is nevertheless safe. So in light of that, I recommend that the approach taken by the Australian High Court be considered by this court in these unique circumstances where we have this unexpected disclosure, and to look the other way at this point to say, well, we can't let that in, that's not admissible, is to put the rule that is meant to ensure justice ahead of actual justice happening. If there is a suspicion that there has been a miscarriage, and there's certainly that in my submission based on what the foreperson has said, then surely we don't uphold the rule that is meant to prevent that, but allow the miscarriage or potential miscarriage to continue. So in my respectful submission, yes, the second juror should be interviewed for the purpose of finding out about the pressure, what he told Mr. Daniels, but nothing else, in order to give as much respect as we can to that rule. But that given what the foreperson has said, it may well be that the court is left with such a suspicion about what the jury actually did or did not do with respect to basing their verdict on the evidence, whether it's a true verdict based on the evidence, or whether they repudiated their oath by not basing it on the evidence and following the instructions, that the court may decide on that basis alone, without more, that the conviction cannot stand.
Right. Thank you very much. That's both clear and helpful. Mr. Richardson.
Good morning, my lords.
Good morning.
I don't have very much in terms of law or at all to add to what Ms. Mulligan has already placed before you. But what I can say is that this is probably an example of something that I was told when I was in law school, that those who like to eat sausages probably shouldn't watch the process by which they are made. So here we are, we now have an insight into what the jury was thinking. And I have to say, my lords, it was quite frightening and very concerning, because if my lords look at pages 16 to 19 of the interview with the jury foreperson, what one sees is something that has been echoed by me throughout these proceedings. And at page 16, line 21, it begins, okay, in terms of the pools, were they always done in relation to both defendants? Or were they separated at all? Do you remember? I think they were, yeah. No, we didn't separate it out, really. I mean, obviously, I remember the judge telling us how we had to disregard some statements, and that if we believed a certain thing, then that automatically meant Katrina would not be involved. That's surely a reference to his lordship's direction that if Mr. Rogers is found not guilty, then he would direct the jury that Miss Burgess would have to be acquitted in those circumstances. And at line 8, it continues. I mean, so I do remember those instructions. My God, I think I had 15 books of notes, 9 or 10 books of notes. Okay, no, all of that was very clear. It was very clear that if we believed, it was always for both. No. It was clear that technically they were both being charged, but we had the choice to separate it. And if we believed a certain fact, then that automatically meant the other, Katrina, was innocent or right. Or he was. Okay, Clevie was, I'm sorry, I can't remember the name, Cleveland Rogers, yes, so what? Yes, that was always clear. Okay, that was an option. It was actually an instruction they were given, but in any event, right, that if we believed a certain thing, that it automatically meant the other one would be innocent, right? So was that issue dealt with first? So that, do you understand? Like, yes, I do. Okay, I can't say I remember that, okay, as being a separate, right, discussion. It wasn't like we went in and although we did actually, come to think of it, we did come in and say, let's deal with this one first and let's deal with that one. But I think as the day progressed, it kind of merged. It merged, and then it became a non-issue. Yes, would you say yes? Yeah, okay. I think the thing that sticks out the most with me was how much we used the so-called
How little we used.
The so-called evidence. My fears with respect to what would happen if the same jury tried both cases are borne out explicitly by that passage we just read. They merged the cases. And my lords, let's be very clear about this. We're all very intelligent, very experienced forensic minds. If that jury rejected the confession evidence and the shoe evidence, what on earth did they convict Mr. Rogers on the basis of? It begs that huge question, and we'd be intellectually dishonest to exclude that question and not run it down. What on earth could they have convicted him on the basis of? And if his conviction is clearly questionable and the judge's directions are right, then Miss Burgess should have been acquitted. But it almost seems as if they switched it around or merged them, as they said, because they could not have reached this particular result in the way that they did if they had followed the judge's instructions. So that's my position with respect to what has happened and emerged from the jury interview. I do agree with Ms. Mulligan's suggestion that you should take the limited steps that you have outlined, my Lord President, to speak to the other juror.
Right.
I do agree with Ms. Mulligan that we should draw a line between asking what their deliberations were.
Right. Okay.
With respect to that issue, that is what I have to add, my lords.
Thank you very much. That is clear. Mr. Mahoney, what is your position?
Well, my lord, first I would like to deal with the authority that Ms. Mulligan made reference to.
Yes.
And in that particular case, that case was not setting any test of a shadow of suspicion. If one look at that particular authority, the situation was that the Court of Appeal thought that in light of the Mercer and Cooper case, they did not have the authority to make any inquiry into the allegation. If one go to the very end of the case, in a nutshell, it was saying, this is at paragraph 66 of that decision. Or starting at 65. Any doubt or ambiguity as to the true meaning of the note might be resolved relatively easily by inquiry of the juror who made the note. An inquiry may reveal either that the physical coercion referred to in the note was no more than robust debate, or that whatever pressure was described, it had in truth no real effect upon the decision of the juror who wrote the note. It may be, for example, that the juror who wrote the note changed his mind about the verdict and about sending the note to the judge after he had written it. Next, it cannot be assumed that the inquiry would be wide-ranging and intrusive into the deliberations of the jury, involving the interrogation of all 12 members of the jury. And in Webb and the Queen, Justice Brennan explained that, excuse me, a possibility that a juror may have been exposed to a prejudicial communication which could not be excluded was an irregularity in procedure, which was sufficient by itself to warrant the setting aside of a conviction, although there was no other ground shown for apprehending that the jury had not reached its verdict impartially. Similarly, in Queen and Connor and the Queen and Mirza, Lord Roger said, since proof of the improper extrinsic influence will be sufficient by itself to make the jury's verdict unsafe, no question of admitting evidence as to the actual deliberations of the jury need arise. Finally, it is to be noted that the respondent did not suggest that the passage of time means that it would not be futile to order such an inquiry. But the practicality of an inquiry, given the lapse of time since the verdict, is a matter for determination for the court by the Court of Appeal. And the order was that the appeal to this court would be allowed, and that the orders of the Court of Appeal of the Supreme Court of Western Australia, made on the 17th of January 2013, should be set aside. The appellant's appeal and application to the Court of Appeal should be heard and determined in accordance with these reasons. So in effect, this case sent back the case to the Court of Appeal for them to conduct an inquiry. The court was not setting down any principle about shadow of suspicion. I've already made written submissions, sir.
Well, just a moment, just a moment.
Yes, sir.
If you go to paragraph 52,
Yes, sir.
there is a series of paragraphs which I headed the proper approach, whereas the passage that you have been referring to is part of a section of the judgment which begins at paragraph 57, which is headed the evidentiary value of the juror's note. But if you go to 55, the Chief Justice says the other members of the court agreed with the test so formulated, although Brennan and Dean differed in the result of the application of the test. This test should have been applied to determine whether a miscarriage of justice occurred in this case. If the note was capable of giving rise to a reasonable apprehension or suspicion on the part of a fair-minded and informed member of the public that a juror has not discharged his task because of unlawful coercion, the appeal should have been allowed unless other evidence put the integrity of the verdict beyond question. If the shadow of injustice over the verdict could not be dispelled, the proper course for the Court of Appeal would have been to allow the appeal, quash the conviction, and order a new trial. So that appears to be the test which the High Court has told the Court of Appeal they've got to apply. And then at paragraph 55, he says, we now know to turn to consider whether the note was capable of giving rise to such an apprehension or suspicion. But the test, which the High Court had specified for the Court of Appeal, is that contained in paragraph 55, isn't it?
But yes, sir. However, if one look at the English cases, the actual test in respect of the evidence, and I'll go through a few of those cases, is what would be the, I think is the informed person test. Sorry, I think that's the actual test that has been used throughout the English cases.
Well, yeah, just a moment, let's take things in stages. What you said a moment ago was that this case laid down no test. Now, it's obviously not an English case, but it appears to me that it does, for Western Australia, lay down a test. Maybe not the one that's applicable here.
I stand corrected on that, sir.
Oh, okay.
However, I just wanted to reinforce the point that this case ultimately was saying that the matter should be sent back to the Court of Appeal for them to do their inquiry.
Yeah.
That's all this case says. And then from there on, depending on the outcome of the inquiry, then the case may go either the conviction may either be quashed or affirmed. That's all this case says.
Well, you say that's all the case says. It's got to go back to the inquiry for them to make inquiries about the juror and then apply the test which the High Court had laid down.
Yes, sir. But I will come to what the English cases seem
Okay, that's fine.
as their test.
I'm perfectly happy to go to the English cases.
Yes,
It's
sir.
just, I think you slightly mischaracterized what the Western Australian case decided. Now, the English cases.
Yes, sir.
Are these the cases you cite at paragraph 3 of your submissions?
These are some of them, sir. Paragraph 3 includes Mercer and Thompson and others.
Now, I'm bound to tell you that I'm not sure that you supplied those to us. You refer to 2 tabs, but speaking for myself, I haven't seen the tabs.
That's in the authorities for the respondent. Those cases were already submitted, sir.
Oh, well, I see. Oh, right.
So if you go to tab 7 of the authorities for the respondent,
Oh, I see.
Mercer is already there.
Oh, I follow.
I can confirm I've got them, Mr. Mahoney.
Okay, right.
And Thompson et al. Is already at tab 6.
Right, okay. Right, yeah, so they are.
I think it's probably quicker if I go through my submission, sir, although I know the court may have looked at it already, sir.
Okay, all right.
I'm starting at paragraph 4, sir. The respondent submits that guidance in analyzing the Benny SC evidence of the foreperson can be gleaned from the case of Thompson et al., where the Court of Appeal in that consolidated appeal had to deal with post-verdict allegations by seemingly disgruntled jurors or jurors seeking to distance themselves from the respective verdicts. As it was in the case of Thompson at paragraphs 15 to 36, much of the foreperson's evidence was directed to the jury deliberation process, the way the jury proceeded, and opinions expressed, which are clearly my submission, section 5A and the Queen and Mercer territory and inadmissible. The respondent submits that the foreperson indicated that she was a holdout throughout. Page 6, line 5, page 8, line 22, page 11, lines 8 to 10.
Mr. Mahoney, you really don't need to read out the reference. Doesn't help us, doesn't show anything.
Does the court need me to take you there, or I can assume that the court has already looked at those sections?
Well, it may be both. It's correct that the foreperson indicated that she was the holdout throughout. You then say, and the opinions expressed of the evidence should be construed as that of her own when the transcript is read as a whole, rather than being the shared views of the other jurors. I think I would like to look at that portion of the transcript to see whether it shows that the opinion expressed was expressed to be her own.
Very well, sir. I would start at page 9, line 2.
Right.
She was asked at the bottom of page 8, right to the end, and can you explain to me, just so for the record, what the holdout, what that means? She said, as in how I felt, as in, or why I was holding out. Question, when you say you're the holdout, your holdout, is that you believe that they should be acquitted? No. Was it both of them or no? Or no? No, it wasn't that at all. I just was questioning what the evidence, what I call the hard evidence, as in shoes, people giving statements, all. Am I allowed to say anything about what we did and didn't consider, or is that not appropriate? I don't think it's important for the purpose of this, and I'll get to why. Okay, why I'm asking you these questions. Okay, because I just want to understand in terms of the split, if any, and how much contention, if any, there was regarding that, and what the progress was, right, in terms of the points that, how did they unfold? Yeah, correct, yeah. Like, so, was there a poll taken 5 times, and she went into that? I will skip over that. Well, sorry, continue, I have to go up to page 13. Like, so, was there a poll taken 5 times, from 11 o'clock, and it was all 11 to 1? Do you know what I mean? God, you're really, I know. I don't mean.
So where are you reading from?
I'm at page 10, line 18 now.
Right.
I don't mean specifics, but sort of the train. We did, as far as I can remember, at least 3, maybe 4 polls, and the numbers would change for guilty each time, as we progress throughout the day. Was there ever a point in time where there was an indication or a general feeling that those who were in favor of acquittal were anxious just to leave? No, absolutely not. And since I was a holdout to the end, I can absolutely categorically tell you I did not feel pressured at all. And can you just explain? Let's go back to you explaining more to me about the holdout. Is it because you were, I heard you say you weren't in favor of acquittal, but can you just explain to me more about why you say you were the holdout? I wasn't comfortable going left or right, if you know what I mean. I didn't feel, I couldn't say yes, but I couldn't say no. I think that's the only way I can describe it. So you were on the fence with both of them. I think so, yes. Now, was that in relation to just one of the defendants, or was it for both? Both. Well, no, I had no issue with the fact that they acted together. That was not an issue. So how did that get resolved then? We obviously debated. It was more, I don't know how I can say this, so I'm just going to say what I'm thinking, yes. And then hopefully you can know that's fine. You can deduct from that what you need to. Essentially, the police evidence was rubbish. Essentially, we threw out all of what I call the hard evidence, the statements by the 2 girls, the shoe prints, it was so, So what we actually ended up working on was just a couple of very basic things.
Now just pause there a moment. She says at line 21 on page 12, essentially the police evidence was rubbish. Essentially, we threw out all of what I call the hard evidence. The statements by the 2 girls, the shoe prints. I mean, it was so. So what we actually ended up working on was just a couple of very basic things. Now that appears to be an indication, maybe right or wrong, that the jury as a whole thought the police evidence was rubbish and threw that out of consideration, the confessions and the shoe prints. And then they ended up working on a couple of very basic things, which were not the confession or the footprints, shoe prints.
By itself, sir, it would appear so. But when one look at the genesis of how she came to be explaining this, she was asked to explain the holdout. And she started out by indicating the reason for her holdout. And
well,
it moved from personal to plural.
Yes, quite.
So that's why I'm saying that if one looked at the transcript as a whole, in how she reached that particular stage, one can appreciate that she was, well, my humble submission is that she was a disgruntled juror who is having second thoughts about the verdict.
Right. Right.
And her emphatic statement about the evidence, the police evidence was rubbish. We threw out all of what I call the hard evidence, should be seen in the light of where she's coming from.
But Mr. Mahoney, I don't understand how you can say in your submissions in paragraph 5 that the opinions expressed on the evidence should be construed as those of her own, because that's clearly not the case from the passage my Lord President's just taken you to.
Well, my Lord, I just indicated to His Lordship that how we reached to that position is that she was asked about the reason, I think, as to why she was a holdout. And she started out by indicating her reason for the holdout. And we ended up with this. Right,
but that's a separate, her reasons for the holdout is one issue. The view that the jury as a whole took in relation to the evidence is a different question.
My Lord, respectfully, it's not really, sir. If one start to read it from page 9 as to how it all started and it came back to this particular point, the question was about her and her holdout.
Yes, I understand that in relation to the holdout, that is her, but in relation to consideration of the evidence, she seems to put the position on behalf of the jury as a whole.
Yes, sir, but I also went on to say that one also has to look at the context in which she is giving the evidence. She is in my submission, a disgruntled juror who seems to be having second thoughts. And therefore, one has to view her comment in that context.
Does she say that? Does she say that anywhere? If she did say it, I don't recall it.
As I go through the cases, sir, you will understand.
Not the cases, Mr. Mahoney, the transcript. Does she say anywhere that she was having second thoughts about her own vote in the deliberative process?
Well, sir, if one look at the language that she used and how she expressed herself, she was the only one who was having a difficulty in the end, because she started out by saying that she was a holdout to the end until she eventually agreed with the verdict.
But where does it say that having held out and then having agreed with the verdict, that she had second thoughts about her decision to agree with the verdict?
One can infer that, sir, my lord.
From what?
From the surrounding circumstances of what she has said. I'm sorry, you can't.
I need to get a
I'm on the camera. I'm sorry, sir.
I'm just not clear where we can infer that she had second thoughts.
As I said, sir, this is one has to look at the case in the round, sir.
Yes, but you made a submission, Mr. Mahoney, that she should be treated as a disgruntled juror who had second thoughts. And I want to know what are the matters from which you infer that?
May your lordship just bear with me a bit so that I could go through the cases and you will see why.
And then you'll come back, and then you'll come back to the transcript.
I'll come back to that, sir.
Okay.
Thank you, sir.
Just a moment. Let's not leave off completely. We can come back to the transcript. But if we continue with the transcript,
yes, sir.
She said at the top of 13, we actually ended up working on, what we ended up working on was just a couple of basic things. And a lot of, mainly it was their behavior, their action, and the telephone calls. So I can categorically say that we all agreed the evidence wasn't worth the paper it was written on. So that's a definite. What the two girls said, we didn't give that an awful lot of weight. Shoe print was, it was also old. I do have an opinion. I think it was very poorly done. And then she's asked about numbers. It's pretty categoric.
Yes, sir. But there is a particular case in which a member of the jury, in that particular instance, did make some statements, I would say, akin to
Okay.
what
All right.
this particular juror said, and you will see how the court actually dealt with that particular situation.
Okay.
And I think it was a bit worse in that case than what we have.
Okay.
And just finally on this point at page 19.
Yes.
So at paragraph 3 to, well, line 3 to 18. Come to think of it, we did come in and say, I know, let's deal with this one first and let's deal with that one. I think as the day progressed, kind of merge, and then it became a non-issue. Yes, would you say yes, yes, yeah, okay. I think the thing that sticks out the most with me was how little we use the so-called evidence. Well, we don't need to go here.
Right.
So it's my submission, sir, that one have to look at the what she says in the round. I'll come back to that after I've gone through the actual cases, sir.
Sorry, when you say these metaphors are sometimes confusing, that we must look at it in the round, then do you mean as a whole?
As a whole, sir.
Right. Okay. Well, I'm sure we should do that.
Yes, sir. I'm continuing at paragraph 6.
Yes.
It is submitted that with most of the jurors having made up their minds early in the deliberations for convictions, the issues would be narrowed and focused on those areas of differences, and there would have been no need to go through all the evidence. This is in response to that portion where she said at page 19, line 14, I think the thing that sticks out the most with me was how little we use the so-called evidence.
Right.
Skipping over to paragraph 8, which is an extract from the case of Babasin, which was sent to the court.
Yes.
Chief Justice Lord Thomas, in the case of the Queen and Babasin et al., in delivering the decision of the Court of Appeal, said at paragraph 60 to 63, we would add that great care has to be exercised before this kind of appeal proceeds. In the Queen and Lewis, this court observed that the inference that complaints after verdicts simply represent a protest by a juror at verdicts with which he or she disagrees are likely to be overwhelming. It was evident to us that each of the jurors who had undertaken public service in an 8-week trial found it deeply distressing to be recalled to court over 2 years later to be accused of wrongdoing and to have their integrity questioned. The allegation which led to this appeal was a complaint by a juror who probably was motivated by the desire to disassociate himself from the verdict for personal reasons, which we have explained. Although that was not known at the time the investigation by the Criminal Cases Review Commission was initiated, the fact that complaint of irregularity was first made after the verdict should henceforth be a very firm indication against the initiation of any inquiry into the way the jury acted, absent other compelling evidence. Jurors are now told in very clear terms to report irregularities during the trial. The evidence from this and other cases demonstrates that jurors take their responsibilities with great seriousness and care, as one would expect of citizens called to perform such high civic duty. The evidence is that they do report irregularities if they occur. We therefore have little doubt that if one of the jurors during the trial falls below the standards expected of a juror, the other jurors will report that to the judge during the trial and before the verdict. That is the presumption on which this court should act. If the complaint is first made after the taking of the verdict, inquiries should therefore not be ordered in such cases and the finality of the verdict accepted, absent other strong and compelling evidence. To do otherwise is neither fair nor just. Jurors doing their public duty should not, in such circumstances, be put through an examination of their conduct some considerable time after the performance of their civic duties. I wish to go to the case of Lewis. Lewis was a case that was sent by email yesterday.
I haven't got it.
It was sent to Mr. Quayle yesterday afternoon, sir.
Not sure it came on to us.
No, I don't think
What
I
was
have.
sent? Sorry, Mr. Mahoney.
It was sent by Mrs. Nelson on behalf of Mrs. Kingdean yesterday afternoon.
It's close to 6 p.m., so Mr. Quayle may not have seen it yet.
Actually, I put those authorities on the cloud. If you give me the reference, I could bring it up on the screen.
It's Lewis and others 2013 EWCA CRIM 776.
And what page or paragraph number?
Starting at paragraph 9. Sorry, paragraph 7.
12?
No, 7.
7.
On the 16th of December, after the jury had returned their majority verdict on count 2.
Just wait a moment, Mr. Mahoney. I think Mr. Quayle is going to bring it up for it, but I don't yet have it.
Do you not see it?
Yes.
I can see it.
Yes.
Paragraph 6. Sorry, paragraph 7, yes.
You have sight of the authority, Justice Bell?
No, I don't. Yes, I do now.
Okay.
Thank you.
So on the 16th of December, after the jury had returned their majority verdicts on count 2, in due course, the jury retired for the weekend. They were due to return to court on Monday, 19th of December, to continue their deliberations on count 1. As we now know, on Saturday, the 17th of December, a member of the jury, Stephen Pardon, went to Lewis's premises and asked to speak to him. We very much doubt that this encounter was fortuitous. When he did so, according to Lewis, he gave an account of matters he said had arisen during the course of the trial. He asserted that extraneous material had been looked at by one juror and spoken of by others. He believed that the members of the jury, in the majority or some of them, had acted unfairly and were biased against the defendants, and they put pressure on one of the jurors to change their mind and convict him. According to Lewis, Pardon said that he had convinced 2 of the others that you are innocent. They then said that we would have to go 10-2. At this point, they managed to bash a woman into submission, and she was in tears over it. He said that the jury were jealous of the defendants and their trappings of wealth, and one or more of them had searched for information on the internet. They refused to look at the substantial body of documentary evidence because some had made up their mind during the first week of the trial. Lewis stated further that Pardon told him that as a result of internet research, the jury knew that the Westwoods were involved, that they actively disliked his wife because she parked her Range Rover between 2 parking spaces in the car park, and were jealous of him because they thought that he owned an Aston Martin, which actually belonged to his brother. He also said that Pardon spoke of one of the jurors as a thieving little bastard with previous convictions. Pardon did not confirm these matters when interviewed. On the Monday morning, Lewis told the solicitor of this conversation, and while the jury, including Pardon, continued their deliberations on count one, the solicitor for Lewis informed the other parties and the judge. While the information was being communicated to and being considered by the court, the jury sent a note to the judge. The judge indicated to counsel that the jury were unable to reach a majority verdict on count one in relation to any of the four defendants. After hearing submissions, the judge decided that the jury should be discharged. We do not know how the jury was divided, but it follows that in relation to count one, at least three of them must have been clear in their own minds that the appropriate verdict was not guilty. More important, in the present context, they were prepared to stand by and return verdicts in accordance with their conscience. The same jury had, as we noted earlier, acquitted Knight on count two. Thereafter, the judge sought guidance from the Court of Appeal about the correct approach to Pardon's activities. At much the same time, on the 19th of December, Pardon approached the workplace of Geely. On this occasion, there was no conversation. He was simply turned away. On the 22nd of December, the parties were informed that there would be an investigation by the West Midlands Police. On the 13th of January 2012, Pardon was interviewed by the West Midlands Police. On the 26th of June, the Divisional Court gave the Attorney General leave to bring committal proceedings against him for contempt of court. On the 8th of November, in the course of the committal proceedings, Pardon accepted that he was in contempt of court. In his affidavit in the contempt proceedings, Pardon did not agree that he had said all the things attributed to him by Lewis. Thus, he denied having claimed other jurors managed to bash a woman into submission and was in tears over it, in deciding that Lewis should be convicted, but asserted that this happened in the context of the conviction of felons. He denied having told Lewis that the jury had checked on all the defendants and knew this and that about them. He denied telling Lewis that he was convicted because he had an established business with Jaguar, or that he was convicted because he had not gone into the witness box. He also denied having commented to Lewis about other jurors. What he asserted was that he had spoken to Lewis because he felt that improper considerations had informed the verdict on count two. He was particularly concerned that one member of the jury had carried out research on the internet and had told the rest of the jury that what he had discovered. He was also concerned that a female juror had, to his mind, been bullied into the guilty verdict. After considering matters raised in mitigation, he was sentenced to 4 months imprisonment. Directly after Pardon was sentenced, a directions hearing took place before the full Court of Appeal. The court directed that the Criminal Cases Review Commission should be supplied with a police interview with Mr. Pardon, together with a copy of the affidavit made by him in the course of the contempt of court proceedings, and asked to carry out investigations of the jury. A, to explore any extraneous material which was used and considered by the jury in reaching its verdict. B, to explore whether any extraneous material was derived from the internet, and if so, to identify it. The CCRC has now produced a report in response to the request made by the court. Given the sensitivities which surround any inquiry into or about or in connection with the deliberations of a jury, investigations of this kind are far from straightforward. We are grateful to the CCRC for the obvious care which characterized the investigations. The question which arises for decision is whether the safety of the convictions is undermined as a result of jury misconduct or material irregularities. In essence, it is submitted that some of the jury may have repudiated their oaths and may have taken account of extraneous material in reaching their verdicts. Leave to appeal on this ground was granted by the full court. The single judge refused leave to appeal on a number of remaining grounds, and some of them are renewed by Fellows and Dealing. We were not asked to, and we did not examine whether what Pardon admitted they said to Lewis or the contents of the interview with Pardon in the course of the contempt proceedings or his affidavit in mitigation of the contempt were inadmissible for the purposes of these appeals. To that extent, the normally rigid prohibition on disclosure of jury discussions, at any rate as admitted by Pardon in the contempt proceedings, had been circumvented. This is an unusual situation, and in future contempt proceedings, the possible consequences of public reference to any matters which come within the proper ambit of the deliberations of the jury will have to be handled with great circumspection. It does not take much imagination to see how a professional criminal might seek to undermine a trial which had resulted in his conviction. In the particular circumstances, we have decided that the correct way to approach the assertions made by Pardon was to examine the Benny essay, underlining that nothing decided in this appeal is intended, nor could it undermine the principles identified by the House of Lords in the Queen and Mercer, Queen and Connor, and Roloff. The jury questionnaire began. So in this case, all the jurors were questioned, my lords.
Right.
The jury questionnaire began by reciting the instructions received by the CCRC, the terms of Section 8 of the Contempt of Court Act, 1981. To explain, each juror was told that the questions simply related to the use of information that did not form part of the evidence was given to the jury. It is unnecessary to set out the questions. However, question 1 read and goes through some of the questions. That's paragraph 21. The results of the investigation can be briefly summarized. 9 members of the jury positively stated that they did not obtain any information about the case from the internet, the press, or any other source, and that they were not aware of any other juror having obtained any information about the case from any such source. One of these 9 jurors mentioned that early in the trial, one of the female jurors mentioned that a florist had said to her when she said she was on jury service that he knew one of the defendants who had been getting away with it for years. The juror reporting this conversation said that as far as he could tell, the juror had not told the florist about the jury on which she was serving, and he did not believe that the remarks were intended to influence her. Indeed, whether the florist was referred to one of the present appellants or to one of the other defendants tried with him, or indeed this trial, is open to some question. If this reported conversation had been of any significance, it would presumably have been reported by Pardon. C1, Juror A, as described by the CCRC, said that at some point during the trial, but before the jury retired, 2 male jurors spoke about looking at the internet to see if a female relative, the daughter or wife of one of the defendants, appeared on it. These jurors were identified by her as Stephen Pardon himself and Juror C. Interestingly, Pardon did not refer to his participation in this conversation, nor refer to the possibility that he himself had used the internet. Juror A did not know whether either of them had actually looked for or at the internet. She did not remember the men saying why they were looking, or indeed whether they actually did so or not. She did not suggest that she heard any conversation based on the internet. She also recollected that the 2 men had iPhones and that they regularly use the internet on these at lunchtimes. As to the conversation she described, she did not remember whether anyone else was present when she overheard it. She commented that Pardon was a bit of a joker, saying things that were untrue. She ended her statement by reporting that at one stage during the deliberations, she had at one point become tearful and emotional, but added that she did not feel bullied by anyone. She was simply feeling the pressure of the long trial. This juror observed that she had seen a news report in the Express and Star on the internet during the trial and saw something about a previous case, but added that she did not read it. She said that they had been told that if they saw any reports about the case, they could tell their family that they were sitting on it, but that they should say no more. We have been shown a copy of what is believed to be the relevant article in the Express and Star. We have read it under the headline 12 sent for trial over bear thefts plot. It showed photographs of 12 men, including these defendants, who were accused of stealing bear kegs in the Black Country, and set out their identities and the charges. It recorded that the prosecution was seeking trial at the Crown Court and bail was granted to them all. This report can have had no bearing on the issues for decision in this appeal. Juror C was specifically questioned about the matters raised by Juror A about possible misuse of the internet. He stated that he had not obtained any information from the internet, the press, or any other source, and he was not aware of any other juror having done so. He had not had any discussion about looking up the wife or daughter of any of the defendants on Facebook. he had not read about the case on the website. Indeed, he said that people were saying that they had not seen the case in the paper. That was one of the ladies sitting behind him, but he could not remember which of them it was. He added that he saw Pardon out of court just by chance, and he knew that Pardon caught the tram to travel into court with the defendants who did not drive to court, a source of amusement to Pardon. Pardon refused to cooperate with the Criminal Cases Review Commission. He has made no further statements over and above those obtained and submitted in the contempt proceedings. It is also clear from his affidavit that Pardon remembered that the jury had been directed not to discuss the details of the case with anyone outside their numbers, nor to visit any of the sites or locations mentioned during the trial. They were also directed that if they had any concerns relating to the trial or other colleagues, they should be drawn to the attention of the jury bailiff. Standing back, the simple reality is that Pardon disagreed with the guilty verdict. He was one of the dissenters. Notwithstanding the clear directions by the judge and his recollection of these directions, none of the concerns he made about his fellow jurors was reported by him to the judge. He confined his comments about the jury to Lewis and someone who was with Lewis at the time. He returned to court on the Monday morning to resume deliberations on count 1. Although Judge Walsh complied with the requirement that jurors should be directed to report any irregularities during the course of the trial itself, and Pardon appreciated the meaning of his direction, even then, before the jury resumed its deliberations, he did not disclose any of the anxieties said to be playing on his conscience to the jury bailiff or to the judge. Given the clear instructions which are now given to juries and obviously were given to this jury, a post-verdict complaint by a member of the jury, whether it takes the form of a letter or a visit to the solicitors for the defendant, or indeed a visit to the defendant himself, simply will not do. As Lord Justice Gage remarked in the Creed and Adams, silence as to any such irregularity will almost certainly mean that this court will assume that none occurred. In view of the additional directions given since Adams was decided, the inference that complaints after verdict simply represent a protest by a juror at a verdict with which he disagrees is likely to be overwhelming. As the court observed in the Queen and Thompson and others, we acknowledge the danger that a juror who is in a minority may be disturbed at his or her failure to persuade the other jurors to his or her point of view, and where the majority has convicted to the sensitivity of a dissenting juror that an injustice may have been done. Once a juror is in that frame of mind, perfectly ordinary events can be perceived as suspicious. In this case, for example, Pardon reported in fairly dramatic terms that a female juror had been bullied into changing her mind. We now know that a female member of the jury did indeed cry, but the cause was not bullying, but the stress of the trial and her responsibilities as a juror. In our view, it seems clear that Pardon was not prepared to accept the decision conscientiously reached by 10 jurors, and at best, he persuaded himself that their decision could only be explained by discreditable conduct by one or more of them. In short, the entire basis of this appeal depends on post-trial assertions. Post-trial assertions,
By one juror.
thanks, sir. By one juror, which was unsupported by any in any material respect. We do not know which of the 11 jurors, other than Pardon, disagreed with the majority verdict on count 2, or the jurors who were unable to agree to a guilty verdict on count 1. We do know, however, that the jury as a whole acquitted one of the defendants in count 2, and that at least 3 members of the jury were not prepared to convict on any of the 4 defendants in count 1. Although an attempt was made on behalf of the appellants to find a distinction between the 2 counts on the indictment, I think I could stop there with that, sir.
Right.
So that is an example, sir, that one has to look at everything in the round, sir, and based on that particular set of circumstances, it would be my recommendation that all the jurors be interviewed, sir, within limits.
What do you mean by that?
Well, sir, the foreperson is saying, and if the court so accepts, that there was no regard to the main evidence, that the jury pretty much disbelieved Katrina Card and Ms. Foley in regards to the confession evidence of the appellant Rogers. If the court is...
You're saying that your submission is that all of the jurors should be interviewed?
Yes, sir, because...
in relation to the jury pressure point and the matters raised in the registrar's interview?
Yes, sir, in the jury pressure point, sir, and whether or not because if the foreperson is saying, and if the court is not with me that what she said in regards to the evidence being disregarded, the main evidence,
Right.
there should be a question about that within limits, sir.
Well, I don't understand what you mean by within limits.
Well, insofar as Mirza and that line of case permits, sir. Because you will notice that from the Lewis case that there were certain carefully prepared questions that were sent to the jurors, and they responded to the questionnaire, sir.
Yes.
And it was premised much on what the juror pardon and reportedly said to Lewis.
And are you suggesting that a questionnaire should be prepared in this case?
That could be one approach, sir. The last case, sir, is a case of...
And who's going to prepare such a questionnaire?
Presumably have to be agreed by counsel, wouldn't it?
That is an approach as well, sir. That has been adopted in these courts, sir.
Yes. There's a bit of a problem when two counsel don't think this exercise should take place.
Yes, sir, but because if one was to follow, well, the argument of Ms. Mulligan would suggest that the juror who spoke to Mr. Daniels should be interviewed only insofar as pressure.
Yes.
But the assertions put forward by the foreperson that there was no regard to the evidence, the hard evidence, to use our word, by the whole panel in reaching a decision. In effect, that submission is saying that we must just act on what the foreperson says, full stop, which cannot be proper, especially in the context that she admits that she was the holdout at all times. And in the terms, sorry, sir?
No, I said right.
And in the terms of the authority, so she could properly be referred to as a juror who is more than likely having a disgruntled juror who seems to be having second thoughts, sir.
Well, there are slight problems about that because she's not somebody who made any complaint.
She did not, sir, but I think the request was made for, well, I think there was something that came up in the paper, sir, when this appeal started. There was a publication of the complaint, the alleged statement made by that unknown juror to Mr. Daniel, and there was something that appeared in the paper, sir.
Yes, yes. I mean, but before, if this appeal hadn't gone ahead, that never existed, the juror who was questioned would have been somebody who made no complaint at all.
That is so, sir. But now that she has been sorry, sir.
Yeah, okay.
Now that she has been interviewed and an issue is now put before the court, I think it is in all fairness that in respect of that particular issue, whether or not the jury totally disregarded the evidence that was presented in court, but nevertheless proceeded to convict, we will require the input of all the jurors. on just those limited questions.
Well, yeah, you say just those limited questions. But I'm just thinking aloud, but if one of the questions is, did you decide the case on the basis that you rejected or didn't find acceptable the evidence of the supposed confessions, they might give the answer yes. And I suppose, I mean, is that a question that satisfactorily admits of a yes/no answer? I suppose it might. The trouble is that carefully drafted questions, quite often the answer, if it's simply left the one response to the carefully drafted question, begs another one. But one could have both. You could have carefully drafted questions, and whoever is conducting the inquiry could ask supplementary questions.
From one experience, I think, can't remember which one it was. I know Mr. Attridge was counseling that one, and I can't remember the name of that case. I'm not sure if it was Princeton Boroughs or it was, but there was another case where there were prepared questions that were agreed by counsel, and the registrar proceeded to ask those questions.
And only those questions?
Yes, sir.
Right.
And at what stage of the process was that, Mr. Mahoney?
This was when the matter was before the appeal court. There was a complaint about a juror or jurors. I'm not sure if it was the case of Simons and
LaShaw?
yes, I'm not sure if it was that one.
I believe you're referring to Princeton Boroughs for the allegation. The allegation was that the juror was known to one of the witnesses in the case and shouldn't have sat. So the registrar interviewed the juror before the appeal so that a transcript was prepared.
Yes, I think that was the one with Mr. Attridge.
Yes.
Yes, I think that was that one.
Yes. Well, that question as to whether or not the juror knew the accused seems to be a good deal simpler than the sort of questions that arise in this case. And the answer is either no, I didn't, or yes, I did. And the supplementary was, how well did you know him? And that's about the extent of the line of inquiry.
I think there were about 10 to 15 questions that were asked.
Okay. Anyway, you say that we should interview all 12.
Yes, sir. Yes, sir. Because if we just leave it to what, following the submissions of Ms. Mulligan, supported by Mr. Richardson, if the juror who is alleged to have spoken to Mr. Daniels, he is limited to just the question of pressure or the issue of pressure. What the court will be left with only is that of the foreperson who was the admitted person who was, to use our word, the holdout juror. And on that basis alone, should make a determination as to whether the verdict of the jury should be left alone or overturned.
Yeah.
And that would not be fair, sir, because she's proposed to be speaking on behalf of all the jurors. This case with Pardon, if the court had adopted everything that Pardon had said and left it as it is, the convictions would have been overturned. However, where upon inquiry, it was shown that Pardon could not be believed.
Right.
And the last case that I had sent, sir, is the case of Hamid, the Queen, and Ol Hamid, 2016 EWCA, CRIM 449.
Paragraph, Mr. Mahoney.
Starting at paragraph 14.
So what's the name of this case? I can't.
It's up on the screen, sir. It's
Well, it isn't because it's not sufficiently down on the screen to see any.
it's I could spell the name, sir. It's IBBTSAM.
Right, Hamid and Khan. Right, okay.
ULHAMID. Yes, sir.
I can see it now.
Hamid
I can
Khan.
see it now. Yeah,
Yes,
yeah,
sir.
okay.
Starting
Right.
at paragraph 14.
Yes.
The jury returned to court at 10:55 a.m. They were asked by the clerk of the court if they had reached verdicts on which they were all agreed with regard to all defendants. The foreman answered yes. A verdict on the count of conspiracy to cheat was obtained in relation to each of the 5 defendants. In each case, as is conventional, the clerk asked the foreman if the jury were all agreed with regard to the particular defendant on that particular count. The foreman on each occasion answered yes. The verdicts were delivered sequentially on that basis. After each such verdict had been given, be it guilty or not guilty, the clerk then also sought the confirmation of the foreman that that had been the verdict on which they were all agreed, and the jury foreman so confirmed. The transcript indicates that no dissent of any kind was conveyed by any juror to the verdict delivered by the foreman as unanimous verdicts. Further, the tape has been played and it appears that there is no audible indication of any expression of dissent. Furthermore, no one appearing at the trial noted any facial or other expressions or gestures on the part of any juror indicating any dissent with or surprise at what the jury foreman was saying. As we have said, the jury convicted these 2 appellants, along with another co-accused, Noor, and acquitted the remaining 2 defendants. All such verdicts, therefore, were stated in open court to be and were confirmed in open court to be unanimous. The jury having delivered their verdict, the judge then, as is usual, tendered his thanks to them. The juror then discharged and left court in the presence of an usher shortly before 11 a.m. At 11:02 a.m., the judge proceeded to discuss sentencing arrangements with counsel. Shortly thereafter, at around 11:11 a.m., the judge was asked by his clerk to rise as a matter of urgency. It was then reported to the judge that the jury usher had said that one juror, who may be styled Juror A, had said to the usher in the jury assembly room after the jury had been discharged that I don't know what to do because the foreman said we were all agreed, when in fact we were not. The usher said that Juror A was to write that down. Juror A then said to the usher that another juror, who may be styled Juror B, had the same concerns. The usher then asked jurors A and B to write a joint note to the judge. That note stated as follows: Defendant 1, the first appellant, Hamid, unsure, not guilty. Defendant 5, second appellant, Khan, unsure. At around 11:30 a.m., another juror, who may be styled Juror C, asked to speak to the usher. He, as requested, reduced his stated concern in a note, which is timed at 11:50 a.m. That note reads as follows: On the 4th person, the accused as Afzal, who was acquitted, we was all stuck on guilty or not because the number was close. It was like 6 to 7 or something along the lines. But some people stated that we had to go the most, which found the person not guilty, which I did not agree. The trial judge very properly informed counsel in open court of the fact of receipt of these notes. Also very properly, he did not feel able to divulge the contents of these notes to counsel on that occasion. The trial judge correctly took the view that so far as he was concerned as trial judge, he was now functus, the jury having been discharged. However, and as again was proper, he referred the matter to the Registrar of Criminal Appeals and submitted a written report in this regard. In due course, the 3 accused who had been convicted launched these appeals. The appeals are based on the proposition that the verdicts were irregular and invalid. They are purported to be unanimous verdicts when the notes as since handed in indicated that the jurors were not in fact unanimous. Moreover, if it be relevant, this was at a time when no majority verdict direction had been given. In the alternative, it is said that even if the verdicts were unanimous, unanimity had been achieved by undue pressure being placed on some of the jurors to fall in line with the majority. Matter came before a constitution of this court on the 4th of March 2015. All parties were represented by counsel. All were made aware of what the notes submitted after trial had said. There was extensive discussion. In the result, a procedure was agreed upon by all counsel and was approved by the court. That involved written questions in the form of a questionnaire being administered by the officers of the Criminal Cases Review Commission to each of the 11 jurors involved. In the relevant respects, the questionnaire was in this agreed form. And it states the questionnaire there. And I will skip over to 19. This questionnaire in agreed form was administered to each of the 11 jurors. A representative of the Criminal Case Review Commission attended upon each such juror separately for that purpose. Of those jurors, 8 of them, without any equivocation of any kind, answered yes to the first 2 questions. A number of those 8 were also recorded by the representative of the Criminal Cases Review Commission, who administered the questionnaire as stated in surrounding conversation, words to the effect that they had gathered that 2 of their number had had second thoughts after the verdicts had been delivered, and that all the jury had in fact been agreed. They expressed surprise that these 2 jurors had not previously expressed any dissent. One juror, who evidently was juror C, who had written the note which we have mentioned shortly after the verdicts had been taken, did not cooperate with the Criminal Cases Review Commission. He did not attend appointments, although several were arranged, and he did not fill in the questionnaire. Criminal Cases Review Commission reported that its view was that he was unwilling to assist. Nevertheless, reliance continues to be placed upon what Juror C had stated in his note as handed in after the verdicts had been delivered at the Birmingham Crown Court. That leaves the position of Juror A and Juror B. Jurors A answered to the questionnaire in the relevant respect to the first question was to write in no. As to the second question, the manuscript answer was no. Another lady was unsure. As to the third question, the answer of Juror A was this: Defendant 1 had expressed not guilty, cross through, unsure. Defendant 1 unsure. There may be some doubt as to whether B was intended to relate to Defendant 1 or to Defendant 5, but the answer in terms refers to Defendant 1. The answer of Juror B to the first question was no. I was under the impression that we had to go with a majority view. To the second question, the answer was no. At least one other jury member had not, unsure about a third person. In answer to the third question, this was said: Defendant 2, I think we're all 100% certain in agreement with verdict. I was definitely unsure about Defendant 1 and 5, but I can't remember whether I agreed in the end with the guilty verdict in relation to Defendant 5. I was new to the whole process, and being honest, I was unsure about both Defendant 1 and 5. I think the other jury member referred to in B had not expressed agreement with Defendant 1. They were unsure about Defendant 1. I believe this juror had been in agreement with the verdict in relation to Defendant 5. I'd like to say that I am uncertain about this jury member's agreement with the verdict in relation to Defendant 5. Those answers having been obtained, the matter came back before another constitution of this court on the 23rd of September 2015, when again all parties were represented by counsel. Mr. Walker for the first appellant and Mr. Jutler for the second appellant were not happy with the answers to the questionnaire. Indeed, Mr. Walker proposed that all 11 jurors should be summoned before this court so that they could be questioned. Alternatively, he proposed a series of further questions that he had not precisely formulated should be administered to the jurors. Mr. Jutler did not associate himself with those proposals. However, he suggested that further questions should be asked at least of jurors A and B as to why they had not raised concern at the time the verdicts were actually delivered in court. This court on that occasion declined in the circumstances to direct any further questions being put to the jurors and declined to permit the jurors individually to be questioned in this court. The questionnaire, as originally formulated, had been agreed by all concerned on the previous occasion. To administer yet more questions would be potentially unproductive, potentially unfair, and oppressive to the jurors, and also might tend unwarrantedly to probe into the jury's deliberations. Thus, the matter has to be assessed today by this court on the materials now before it. It is only in the most, the legal approach, it is only in the most exceptional cases that inquiries as to the way in which jury verdicts have been reached will be directed. The reason is clear. The sanctity of the jury's private deliberations must be respected as an integral part of the jury system. Were it otherwise, the jury system would be gravely undermined. In this particular case, on the special circumstances which arose, a constitution of this court on a previous occasion had been prepared to direct that inquiries be made of the jury through the good offices of the Criminal Cases Review Commission in the manner we have indicated and had obtained the information as we have indicated. In the Queen and Shanley, a juror had complained immediately after verdicts purporting to be unanimous had been delivered that the jury had not in fact been unanimous. Investigations were made and it was conclusively established that that complaint had been accurate. The jury had been divided either 8-4 and 9-3 on the relevant counts when the purported unanimous verdicts had been announced by the foreman. That was indeed so was not only confirmed by the subsequent inquiries made of the jury, but also entirely accorded with jury notes which had been sent into the judge shortly before the verdicts were delivered. In those special circumstances, the constitution of this court set aside the verdicts in Shanley. They had not been as they had been purported to be unanimous verdicts. Indeed, no majority direction had been given in any event. As Sir Igor, Judge President of the Queen's Bench Division, put it, in reality, there were none verdicts returned in error by the foreman. In the Queen and Babasin and others, this court was concerned with a situation where various alleged irregularities in the jury process was raised after the trial had concluded. Although it is to be noted that the alleged irregularities in that case did not extend to assertions that verdicts purporting to be unanimous had not in fact been unanimous. In the context of the kinds of irregularities there being alleged, Lord Chief Justice, in delivering the judgment of the court, speaking in general terms, said this, and I've already referred to this in my submissions. Conclusion. In the present case, Mr. Walker and Mr. Jutler both emphasized that jurors A and B, and indeed juror C, had expressed their concerns only a relatively few minutes after the verdict had been given and before they had left the court building. It was submitted that credence should be given to those concerns. Those concerns are set out in the notes put in at the time and are since set out in the answers to the questionnaire from jurors A and B, indicating to submitted that the jury had not in fact been, contrary to what had been represented, unanimous. In our view, this court must view such submissions with very considerable caution. It is indeed a relevant matter we accept that concerns were swiftly raised. There is certainly no reason to think that any kind of external influence has been brought to bear on these particular jurors. But the position can arise when verdicts are being returned, for example, from the reactions of the defendants or their families, be it tears or otherwise, or from the reactions from the public gallery, or indeed perhaps just on further reflection as to the significance of actually returning guilty verdicts, which may render unreliable purported statements thereafter that the verdicts were not unanimous and that an individual juror or jurors had not been sure or had not agreed with the verdict at the time. In other words, second thoughts. However, speaking generally, second thoughts after a verdict had been delivered are not relevant. What matters is whether the jury had been unanimous at the time when the verdicts were delivered. A subsequent change of heart, even if it occurs swiftly thereafter, simply will not do. It is therefore irrelevant where a juror has indicated assent to a verdict for the juror thereafter to say, after the verdict had been delivered, that in his her mind, she had harbored doubts or was unsure. It is also irrelevant where a juror has indicated assent to a verdict, that juror thereafter to say that she had in fact been unsure, but had simply gone along with the majority. What counts is the ostensible demonstration of assent in the jury room to the verdicts as actually thereafter delivered in open court. Overall, ostensibly, regular jury verdicts as delivered are to be respected and most certainly are not likely thereafter to be interfered with. And the decision of the court in this case at paragraph 31, the present case on any view of the matter, there can be no question whatsoever of any wholesale repudiation of the jurors' oaths. Further, 8 of the jurors were subsequently unequivocal that the verdicts had indeed been unanimous at the time. The reaction of juror C, both in the immediate aftermath of the verdicts and thereafter, was most unsatisfactory. and in effect can be discounted. Certainly what Juror C said in his note as handed in after the verdict had been delivered to the trial judge gains no support from anything that any other juror, including Juror A and Juror B, had said, and was in any event equivocal. It might well be, for example, that at various stages in their deliberations, the jury had indeed been divided, but as the deliberations continued, they all came to a unanimous view. It is true that Juror C had said in his note, which I did not agree, but he does not state and has never since stated that he expressed that disagreement to the other jurors in the course of their deliberations before they agreed on their verdicts. And I stop there, sir. And the outcome of this case was that the appeals were dismissed. Hence, I'm back to whence I started, sir, that I believe in the circumstances of the assertions made by the foreperson, a self-admitted the person was holding out and had her doubts all along, that it will be wise for this court to have some input from the other 11 members of the panel on that particular issue that she raised, the evidence.
Well, if we're going to have input from the other 11 members as to whether, in effect, there was a wholesale repudiation of the juryman's oath, we might just well ask them whether or not they decided to convict, or at least some of them decided to convict because they didn't want to go to a hotel. If we're going to embark on this exercise, it might be thought to make little sense only to deal with the question of jury's deliberation.
And following on from that, Mr. Mahoney, if we're going to go that route, presumably it means that we should not now interview the juror who spoke to Mr. Daniels.
Well, he would be part of the other 11, sir.
Yes.
Yes, sir.
Yes. I mean, there might be some, if we're going to perform this exercise at all, of having all the jurors, then I'm thinking aloud again. There might be some sense in asking the juror who reported to Mr. Daniels first, because if he says, no, I'm sorry, that's not correct, actually. We don't need to embark upon asking 10 others whether it is, or 9 others.
Yep.
Well, it all depends on what the court determines. In other cases, the court just dealt with what the particular juror said and did not say in their note or evidence. As a
yes.
issue. So
yeah.
It's for the court, sir. Sorry, sir.
Yeah. No. I mean, the trouble is that both in relation to the sequestration point and in relation to the deliberation point, the evidence so far given by directly or indirectly by the relevant jurors is that it either affected all of them in the deliberation point or half of them in the sequestration point. It's not I thought this, it's that 6 of us thought this. Right, okay, well, thank you very much. We have your, are there any other observations you desire to make?
No, sir. Those are my submissions, sir.
Thank you very much. Do either of the appellants' counsel wish to add anything or say anything by way of reply?
If I could, I'm a bit surprised at Mr. Mahoney's position now. It wasn't what I gathered from his written submissions.
That's because it doesn't appear in his written submission.
Yes, so I mean, I guess my earlier submission was that no further inquiry is necessary of the other jurors if one were to follow the Smith case. But if one were to follow, I suppose, more closely the line of cases that have now been read quite extensively, where questionnaires have been used, then I don't take any particular strong position that the other 11 shouldn't be asked questions if the questions can be agreed upon with respect to whether some or all of them repudiated the oath, and with respect to some or all of them felt jury pressure or pressure by sequestration. So I guess I'm submitting that, I don't have a particular disagreement with all 11 being asked questions. I was trying to take sort of a conservative approach, I guess, but
Okay, that's helpful. Mr. Richardson, is there anything you want to add?
This stage on this point with respect to the jury issue, no, my lords.
No, okay. Well, we will take a break before we go on to item number 2. We will be at least 10 minutes. I don't mean by that that we will necessarily have reached a conclusion, but we need 10 minutes to think where we go next, and we need to break in any event. So if you could be available no later than 10 minutes from now, I do not warrant that in 10 minutes' time we will in fact be ready to resume.
Cleveland, you're on mute. You're on mute, so I can't hear you, but I don't want to have a discussion in this forum with you. If you want to call me, get them to give you a call. That would be better than having it a private discussion here that may not be private. Your mic is muted anyway, so I can't hear you. I can, oh,
Ms. Mulligan? Okay. And Mr. Richardson?
Right.
Right, we're all here? Yes. Right, well, we're most grateful for the submissions which we have received, which we have found helpful. The course that we propose to take is this. Firstly, we think that it is desirable to question all of the jurors. All 11 jurors, because we've dealt with the foreperson. It doesn't seem to us satisfactory to question all 11 and to question them on both topics. That is to say, as to whether or not the verdict was reached because a proportion of the jury wished to avoid sequestration, and as to the deliberation point, which I'll come to in a moment. In relation to the latter, it doesn't seem to us satisfactory to leave the matter hanging on the material evidence volunteered by the foreperson when she was being asked about whether there was pressure to reach a verdict to avoid sequestration. Accordingly, we think that what should happen is that counsel should prepare a list of questions to be asked in relation to both points, the pressure to avoid sequestration point and the jury deliberation point. And we will consider those questions and see whether they should go forward either in the form suggested or in an altered or amended form. In relation to the deliberation point, it seems to us that the critical question is as to whether or not the jurors accepted the validity of the two confessions by Mr. Rogers. If the answer to that is no, in circumstances in which the judge had indicated that they would have to be satisfied as to those before Mr. Rogers could be convicted, and that if he wasn't convicted of murder, Miss Burgess couldn't be convicted of aiding and abetting. In those circumstances, if the jury weren't satisfied as to the confessions, it would seem that the appeal would fall to be allowed. If, on the other hand, the jury were satisfied as to those confessions, the position that they took in relation to the footprints or the telephone calls might be thought to fade into insignificance. So whilst we are not telling you not to include in the questions anything about the footprint or the telephone calls, we give notice that we are preliminary of the conclusion that they are secondary and that it may not be appropriate actually to pursue questions on that topic, but that's for determination hereafter. So we invite counsel to draft questions on both topics It seems to us that it should start with the Crown, and those questions can then be circulated, and the counsel for the appellants can make their alterations or suggested additions to those. We also think that the questioning should, in the first place, be by written questions, without prejudice to the fact that in the light of the answers, we might decide that it was necessary to have some oral questioning. But that is a matter which would be desirable if we could avoid, and which in any event would have to be left over until we have received the answers to the written questions. Last, we think it sensible to start the questions with the man who spoke to Mr. Daniels at the Garden Centre, to ask questions of him under both heads, to ask questions of him under the pressure heading. That is to say, whether or not half the jury reach their verdict because they wish to avoid sequestration. The logic for that approach is that if he were not to confirm that that was the case, and were to say that, I don't know, although he said that it wasn't true, or he was exaggerating, or whatever, so if he were to renege on what he is said to have said, it might then prove unnecessary to ask the other members of the jury, other than the foreperson who's already been asked, what the position was, because she has denied that there was pressure to reach a verdict on account of sequestration, and if he were to renege on it, that would be it. So we think that in the first instance, he should be asked, he should be the first person to answer questions, and to answer questions as to the sequestration point. Thereafter, either questions will be asked of all the jurors, other than the foreperson who's already been asked, on both the sequestration point and the deliberation point, or only on the deliberation point. And the man who spoke to Mr. Daniels will then be asked, having already answered questions on the sequestration point, for answers on the deliberation point. I hope that's intelligible. If it isn't, you're free to say so. But as I say, that will mean that we will need questions to be drafted, and we will have to consider them. And they will then have to be asked, firstly, of the man the male juror in question, and then of all the others, save the full person who's already been questioned. Is that tolerably clear?
Clear to me, sir.
Yes, thank you.
Well, that's encouraging. The slight silence caused me to wonder whether the answer might be no. But right, okay. Now, the next problem that arises under this heading is how long all this is going to take. When we met before, we had hoped that it would be possible to ask questions simply of the single relevant male juror, and we could then resume on this topic next week, but that's not going to be feasible. Self-evidently, one would like it to take place as soon as possible, but it's not going to take place next week. I think all we can say at this stage is that we need, please, your draft questions as soon as can practicably be done, Mr. Mahoney, are you able to give us any idea as I speak as to how long you think that might take you and your team?
Well, I'm not sure how long we'll be going today. I could start working on it today. We have staff training tomorrow and Friday, but I will still try and see if I could get it completed by Friday the latest.
Well, that would be very helpful. What about counsel for the appellants? Would they be able to produce a response, do you think, by the end of next week?
Yes, I don't see why not. Mr. Riches and I can discuss it together and hopefully come up with a common response from the appellants.
Well, that would be very helpful. Let's try and work to that timetable. And then we will put into action the asking of questions, firstly in writing, which will start with the male juror we're all talking about.
Is it, may I ask if it's envisioned that the jurors would be brought to the registrar's office or somewhere to answer the written questions?
The short answer to your question is that I haven't addressed my mind to it.
I was just thinking it might be unwise for them to be doing this, you know, sort of with the questions at home, talking to people. It may be a more formal and
Yes.
just their thoughts. If it's at the registrar's office or somewhere in the court precincts.
Yes, well, that may be a sensible method of proceeding, unless anybody.
I can confirm that the juror foreperson was interviewed in chambers before the registrar. And where there's court smart, so that way the proceedings can also be transcribed if necessary.
Yes, the complication is that the question at this stage is whether in their answer to the written questions, they should do that in the presence of the registrar, rather than whether they should be asked a series of oral questions by the registrar. But I think that it's probably sensible for them to answer their written questions in front of the registrar, in case there's some confusion as to what the question means. Unless either of my colleagues or anybody else has a different view, I would suggest that we proceed upon that basis. Right. Well, that's the first of the, and then after that, we will see what the male jurors' answers are on the sequestration / pressure point. We will see where that takes us in relation to the necessity or desirability of asking the other jurors on that topic, though I strongly suspect that it would be necessary to ask the other jurors on that topic, because I rather doubt that the male juror will say, no, I never said that, or if I said that, it wasn't correct, but stranger things have happened. And then we will also have to, in any event, ask all the jurors other than the foreperson for questions in relation to deliberation, in relation to everybody other than the male juror, first male juror. Those two topics can be dealt with at the same time in written questions in front of the registrar. In the case of the male juror we're talking about, he'll have to have 2 sessions answering written questions. Right. Thank you very much. Now, the next item, the last item on today's, we will then, in the light of all those answers, have to relist this appeal for hearing submissions in relation to those answers, though we may invite written submissions beforehand. Right. Now, the next item on the programme is the significance, any, of the discussion that took place on the 26th of February before the speeches to the jury and before the summing up, which appeared to include a discussion about the hater direction. And in relation to that, if we go in, if you could have open the discussion, if one goes to page 22, let me just find it. Yes, if one goes to page 22, after previous discussions about premeditation and the like, and admissions, at 22, line 13, Mr. Mahoney says, is it time to revisit section 88 hater? Could you just tell me what section 88 is a reference to?
That's of the case, sir.
Sorry?
I think that is a reference to section 88 of case.
Oh, I see, of PACE. I'm so sorry. Yes,
Yes,
I
sir.
follow.
Conviction as evidence of commission of offense.
Yeah, oh, I see. Yes, yes. I follow. And you say, is it time to revisit the section 88 hater? The judge says, I wake up every morning thinking about hater. Mr. Richardson says, I hate hater. And the court says, my position currently, and it may change when I wake up tomorrow morning and the morning after that, and the morning after that, my current position is that I was not going to direct them along the lines of hater. And you replied very well. And then the judge says, you seem suitably confident in any event they're going to do it in their own minds. So they probably don't need any help on that subject from me. Do defense counsel take a position on that? And Mr. Richardson said he's right. Now, I think he's right. They're going to be tempted to do that in their own minds. But of course, and then the judge says, I mean, I have to be, and Mr. Richardson says, I've written a portion of my speech that I think will disabuse them of that notion quite thoroughly. The court, right, I mean, I have to obviously in the usual way advise them they have to consider the case against, yes, Mr. Rogers, and they have to consider the case against Ms. Burgess, and they can only consider those cases, and which they must consider separately on the basis of the admissible evidence against Mr. Rogers on the one hand. And Mr. Richardson says, right, yes, yes, the standard one. The judge says, but I will likely advise them too, because it just makes sense the way the indictment is drafted, to consider the case against Mr. Rogers first. Then Mr. Richardson says, yes, fair enough. Now, it looks to me, unless I have misread it, that the judge was saying, apart from the fact that he lies awake at night in relation to thinking of hater, that he wasn't going to give a hater direction or take a hater approach, but was simply going to say that you have to determine as against each defendant separately the evidence that is properly admissible against him or her. Whereas in fact, it could be said that he has taken a hater approach because he's proceeded on the basis that they must first consider whether or not Mr. Rogers is guilty, and then if they find that he is, which will be on the basis of evidence admissible against him, they can then go on to consider, he being the murderer having been established, whether or not she was an aider and abettor, notwithstanding that the evidence which are the confessions, which he held was essential to be believed if Mr. Rogers was to be convicted, is not evidence against Miss Burgess. That's one reading of the position. It's fair to say that, well, the judge said he might change his mind about the hater position, but on the course suggested at this stage, he appears to have indicated that he was not going to proceed upon a hater basis. So it's in relation to that we would welcome submissions as to its significance or otherwise.
Yes, my lords, I suppose I should tackle it first. When I first saw that the transcript with respect to the discussions on the summation had been reproduced, I wasn't exactly sure what the significance of them would be. His lordship now having directed me to that particular portion and now asking the question, did the judge in fact go ahead and adopt in substance a hater approach? My answer would be yes. In this discussion, as you can clearly see, my lords, it was always my concern. It was my concern from the moment I applied for severance that whichever adjudicating mind was applying itself to the facts in this case, that it was paramount importance that they considered the cases completely separately and that they did not merge or mix any of the evidence that was admissible against one defendant against the other. That was always my guiding concern. And when we began to consider the hater principle, it did cause me concern, that hater modification, because that modification, as I think we now accept, was a little step further than one would usually go. I don't understand my learned friend's reference to Section 88. Section 88 of PACE allows you to pray and aid a conviction when you were trying another defendant. This jury could not convict, then rank that as a conviction under Section 88 and go ahead and use it in the way that the section envisages. So I didn't understand the reference to Section 88. It did seem that my learned friend wanted to stay away from committing to the hater position. And I suspect that is because hater looms so heavily in the severance application that had there been an indication that the hater approach would have been taken by the Crown, severance may have been granted. And that, to me, my lords, is a reasonable explanation from which you can clearly see is why my learned friend stayed away and wanted to stay away from relying on that particular modifying principle like the plague. But here we have it now. The judge himself at the 11th hour was undecided as to how he would direct with respect to hater. And in actual fact, if you look in the record, I don't think we returned to that discussion again. And his lordship eventually directed in the way that he did direct.
Well, that is true. I don't think you did in the record return to that, though equally, after the summation was over, which, as you submitted, proceeded on a hater basis, you didn't, and the judge asked for any comments, you didn't say, well, wait a moment, you said you weren't going to proceed upon a hater basis, and that's in effect what you've done.
Well, my lord, what I can confess and say is that it wasn't until having actually read the judge's words subsequently, because he didn't use the language and the formulation of hater, which would have been pretty clear.
Yes.
He didn't tell the jury to use the conviction of one or finding on one as a building block. I didn't hear that in detail, so it didn't quite trigger me enough. But I do accept, my lord, that had I been sharper, I probably would have caught it. I didn't catch it until afterwards. And having now noticed it, his lordship so rightly considering it. But no, I didn't raise that issue at the time.
Okay.
And I feel that if I had, his lordship, in an attempt to clean it up, may have made matters worse.
On one reading of the passage that my Lord the President has read out, there seemed to be an acceptance that the jury didn't need to be directed about Hayter because that's what they were going to do anyway.
Well, my lord, it's not particularly clear from this passage, but what you can tell from the context is that when his lordship makes the comment that, well, Mr. Mahoney, I know your view is they're going to do it anyway. Mr. Mahoney does not reply, but that is because we have previously in the trial canvassed this issue, and my learned friend from the prosecution made it quite clear that he was really indifferent as to whether or not his lordship used Hayter or not, because realistically, in the jury's minds, that's what they would do anyway, which is the very danger that I was trying to guard against from the beginning.
And that's why when this was being discussed in the terms that we've just seen, anybody taking objection to the jury adopting a Hayter approach must surely have been bound to stand up and say, well, my lord, the direction that you've got to give is that you, the jury, must not take the Hayter approach. Otherwise, as everybody seemed to agree, the jury were going to do it.
Yes, my lord, but if you look at what the judge says at line 18 on page 22, he had made it clear that at that stage in the proceedings, as we were having that discussion, he was not going to give the direction. So I didn't see, it didn't occur to me there was any need to press it any further. Had he come and said, I've decided now I'm going to give that direction, we definitely would have had further discussions about it. But at that stage, his lordship had indicated, and throughout this trial, the indications being given, because I was the one asking for them because I was so concerned, were that no, we're not, no, we're not, no, we are not. So that's the position I was faced with, my lord.
Well, it is true that he appears to be indicating he wasn't going to give the direction, but I think what the point that raises is this: if he wasn't going to give Hayter direction, but in effect the jury were going to act as if he had, that is to say, treat the conviction as if established against Rogers as, the murder, if established against Rogers, as established against Burgess. If the position was that that was what the jury was going to do, although they hadn't been given a Hayter direction, what my lord was indicating was that the one thing that the summing up would need to do was to say, you mustn't do that.
That appears to be the direction his lordship went, but as we know, that did not transpire. And his lordship never actually came back to us and gave us a definitive answer as to whether he'd come down on one side or the other. Had that step been taken, I am sure we would have had further discussions about it.
Right. Right. Yes.
My lord, unless you're pointing out other issues in the discussions before summing up.
Well, sorry. No, well, not on this point, but there is another issue which may be of relevance. If we go to page 38, sorry, I'm trying to scroll down rather incompetently. Yes. Yes. Well, at 37, after quite a bit of discussion, at line 22, Mr. Mahoney says, the issue is, do you believe what he said, that he did it? The court, yeah, for whatever reason he gave. For the court, yeah, the importance of the direction in respect of that aspect of the confession is just to make it abundantly clear that that's no evidence against Mr. Burgess, Mr. Richardson Holmes. That is why whatever he says is evidence against himself. So on what basis could they convict? He said he did it. Convict, and of course what the judge intended to ask was, convict Mr. Rogers, but not Miss Burgess. And Mr. Mahoney, well, they may believe that she told him, yes, go and punch him up, but the guy went a bit too far. Mr. Richardson says, really, that's speculation. Mr. Mahoney, I don't know. Mr. Richardson, that comes out of your mouth. I'm jumping up on top of the podium. Mr. Mahoney, I don't know, but they didn't lead that evidence. So you can't lead that, sir. They can't leave that. Mr. Richardson, my learned friend, Mr. Mahoney, I mean, could have gone that way, but they didn't, because she could have said, well, yeah, I had a chat with him, told him, go do him something, but I never, yes, just slap him up front. And the next thing he went and killing the guy, I never expect that. Yes. Mr. Richardson, that wouldn't make her guilty of murder now, would it? We got a whole different set of directions to go with now. Mr. Mahoney said, that's not the case. The court, no, what we're saying is that that's not the way you went. And then Mr. Richardson says, okay. Mr. Mahoney, right. The court, so we don't have to go that way. Mr. Richardson, okay, fair enough. Now, that appears, on one view, to accept that it wasn't necessary to go through the possibility that all that Miss Burgess had asked for was to go and punch him up a bit, which doesn't, if that's the right analysis, fit that well with the proposition that the judge failed to leave every possible scenario open to the jury for consideration.
Yes, my lord. That particular passage, I think the discussion began actually because I raised the issue. The issue was raised as to whether or not, as the Queensland Code allows, the jury should be directed as to the basis for their verdict, because it occurred to us that Mr. Rogers could be convicted on one basis and the jury could be convicted on the other basis. However, the Crown hadn't run their case in that way, and we had a discussion prior to this as to whether or not alternative should be left. And Mr. Mahoney for the Crown, I believe, took the position that it was a premeditated murder case, and that was it. So at this stage, for any alternative theory to be left to the jury, in light of the fact that it was a premeditated murder charge, was not, so far as we could tell, the actual factual hypothesis Mr. Mahoney was proposing was not available in the evidence. We never proposed a specific factual hypothesis. What we said is that the judge should have explained to the jury, since this was a premeditated murder case, that there are circumstances in which they could be satisfied that she didn't have that mens rea, but maybe he did, or whoever the killer was did. That wasn't made clear to them.
Well, I know that's what you're saying.
Yes, what we're dealing with here, my lords, in my humble submission, is Mr. Mahoney actually wanting to propose a specific factual scenario, which I believe he was just extempore hypothesizing, which we all agreed right there and then could not possibly be open on the evidence. We'd be asking a jury to speculate. We wouldn't be asking.
Which is what you said.
Sorry.
Which is what you said to the court when that first came up.
Well, it's a different matter for a judge to leave to a jury that there are circumstances which could fall short of the completion of the required mens rea without having to spell out some conjured up hypothetical factual scenario. That's not what we were asking for. We couldn't leave a hypothetical factual scenario to the jury. But this judge, we say, was duty bound to go further than he did on premeditation. It seems as if all he did, and it's replicated in this discussion, we all agree that whoever did do the stabbing intended to kill this gentleman because of the force and the severity of the wounds. We didn't concede anything further than that, and none of that relieves the judge of his duty to make it clear that Ms. Burgess had to have premeditation, and that anything short of that would mean she was not guilty. And he could have given examples of what would have fallen short of that without actually speculating. But the example that Mr. Mahoney wanted to give with all that factual detail would have amounted to speculating. And that's the position that I took and I still take.
I'm looking at pages 76 and 77 of the summation.
This formation or the transcript we're in now, my lord?
Of the summation. Where the judge first sets out section 286 of the code, defining premeditation.
Yes, my lord.
Then says the prosecution must satisfy you beyond a reasonable doubt, so you feel sure that the defendants, plural, had the specific intent to kill, etc. It's not enough that the defendants intended to do some harm, no matter how serious, short of death. And then he goes on all the circumstances. And then there's the passage on 77 that we've looked at in the past. I don't think in this case there's any issue taken by the defense for either Mr. Rogers or Miss Burgess that the person who stabbed Marcus Gibbings, causing the injuries you've heard described, had any other intention in mind but to kill Marcus Gibbings. So there's no, that shouldn't cause you any difficulty.
Yes.
It's clear from those 2 pages read as a whole that in relation to your client, the prosecution had to prove an intention to cause death deliberately formed before the murder took place.
Yes, my lord.
So what's the problem?
Well, the problem, my lord, is that although they were told that that mens rea had to be found on behalf of Miss Burgess, they've been given absolutely no guidance as to what evidence could possibly satisfy the answer to that question. And in a case like this, it was imperative for a jury to be directed and at least given some assistance by his lordship as to what evidence might be capable of satisfying. It's a matter for you, ladies and gentlemen of the jury, but you might find that this might or that might. No assistance of that was given. And it is not surprising now that we see the jury transcript where they essentially did their own thing. They should have been given some guidance. No panel of laymen would have been able to apply what his lordship just read in those 2 pages, that very concise, simplified, stripped down version of a direction that should have had far more detail to it. That's the position we take. This verdict can only be safe if this jury properly understood the law and how to apply it to the facts, not from the speeches of counsel, but from the direction of his lordship, and then properly apply the two to each other. That clearly didn't happen in this case, my lords.
There are 2 different questions. One is the one that you've just dealt with in answer to the questions posed by my lord. You say that the jury were not told what evidence could satisfy the test of having to show of establishing premeditated murder. That's one point. They weren't told how you could reach that conclusion. But I had thought your other way of putting matters, or another of your complaints, was not that one, although that continued to apply, but that the judge hadn't spelt out the possible different scenarios which the jury could find to be consistent with the evidence, which would not amount to which would not amount to aiding and abetting premeditated murder. One of which, for instance, might be that she agreed that Mr. Rogers could go and rough the victim up, but had no idea that he would be murdered. Isn't that another of your points?
My lord, yes. And essentially, this is the way we put it. Perhaps I should remove the plural and should make it singular, but my position would be that when directing this jury, that you have to find a specific intent element like premeditation. The judge had a duty to also indicate to the jury that if you are not satisfied that she had that intention, she would be not guilty of premeditated murder without having to give a factual scenario. One sentence could have cured this. Ladies and gentlemen, you may find, as the Crown's case is, remember the context, the Crown's case is that she lured him there. The Crown's case on the admissible evidence against her, the narrative ended there, that she lured him there and she appears to have built a false alibi. Fair enough, wonderful narrative. But why did she lure him there? That evidence was inadmissible against her. For what reason was Mr. Rogers going to be there? That evidence was inadmissible against her. What was the intention? If she did lure him there and the evidence against her stops there, once he got there and took the lure, the rest of that was inadmissible against her. And that is the point. The judge should have made it quite clear that there are scenarios, he didn't have to go into detail, in which you could find that perhaps she did lure him there, but that she had no specific intent that he would be killed. And if that's what you find, she'd be not guilty of premeditated murder. It's a simple addition of 2 sentences, which would have made the matter crystal clear. And we wouldn't be having this discussion, but they weren't left with that alternative. They were almost basically told, listen, whoever stabbed Mr. Gibbons intended to kill him. End of story, it's premeditated. That can't be right. And I don't see any other way to characterize it, my lord. That cannot be right. This direction on premeditation was far too diluted.
Right. So what's the sentence that he should have added?
He could have simply said to the jury, after explaining what he has said with premeditation, that, ladies and gentlemen of the jury, if you find that she lured him there, but that she may have not had the intention to have him killed, she'd be not guilty of premeditated murder. And that's where it would have come into play for his lordship to say, in considering this delicate question, you might want to look at this piece of evidence, or you might want to look at that. But I'll be quite frank, there wasn't anything he could point them to in the evidence admissible against her to establish premeditation. So in essence, even if he would have tried to do the right thing, he wouldn't have been able to, because there was no evidence to point them to, which brings us right back to the fact that the no case submission should have been granted.
Right.
I just don't see how it all ties in together, as my learned friend says, in the round, on the whole.
Yes. Right. Thank you. Ms. Mulligan, have you got anything to say on this topic? Don't feel you have to.
Oh, I don't think there's anything I can usefully add. They don't really touch and concern Mr. Rogers.
Yeah, that's what I thought. Right. Mr. Mahoney.
Sir, just to deal with the last issue first. If one look at, I'm looking at the transcript of the discussion of the law.
Yes.
At page 14, line 25. Starting there where I said, well, the usual murder, premeditated murder. The court, right. I know that defense counsel have on a number of occasions used the term murder word, use the murder word. So what is the defense position in respect of murder, premeditated murder? Because I was very attuned to the fact that you, I think, have both used the word murder. Mr. Richardson, Court, so it's accepted that this is a premeditated murder, or is it accepted that this is by whoever committed it, but not your clients? I mean, I still have to give the direction on intent and premeditation, but is there, Mr. Richardson, are you trying to determine whether you have to direct this jury or whether or not they have to find that a murder was committed? Well, I mean, obviously, Mr. Richardson, and the elements of it, the court, I'm going to have to give a direction on Mr. Richardson, I would say on the face of it, that whoever did do this, did it with the intention to kill. That's the best I could say. Right. And that's what so that would be premeditation. So Richardson, no, that wouldn't be premeditation, that would be murder. Right. Yeah. Premeditated murder is something different again. You may have to give them a direction on premeditation. Yeah. Well, I have to give those directions anyway, but what I want to be able to, Mr. Richardson, but as to the elements of murder, the court, I want Mr. Mahoney disagree with that. Right. Obviously, I'm going to have to give all the directions in any event on killing, what killing means, to cause the death, the fact that I don't think there's any suggestion that this is not an unlawful killing. So I'll have to give them the direction that it has to be an unlawful killing, but indicate to them that there is nothing in this case which would suggest that this was anything other than an unlawful killing. And then I will obviously have to direct them in respect of premeditation. But your position certainly is that the person who did this had an intent to kill, as opposed to an intent to do grievous bodily harm. Yes, Sir Daniels. Sir Richardson, I don't think we can dispute that. Court, right, okay. I mean, I was only going to make reference to, I think it was Dr. Oberfunwa talking about the amount of effort, or I think he said it was uncontested in respect of one of the fatal injury, that it would have required considerable force, or I forget the word he used, so Daniel's considerable force. But if it's not going to be an issue that there was an intention to kill, then I don't need to go into too much detail in respect of that. Okay, but yes, I will go through all of the sections. And that's where we had left that on that basis. My Lord K and my Lord President had actually made reference to page 37 onwards, where there was no doubt that there was no alternative verdicts being put forth by the appellant. It was either premeditated murder or not. I've heard my learned friend where he has a particular formulation that the judge should have used. I say it's a matter of semantics. The learned judge, in putting the case to the jury, repeatedly indicated to them that, one, do they find that she lured him there? And if so, was it with premeditation that he was to be killed? So there was no fault in looking at the directions as a whole.
Well, yes, the direction that is suggested that the judge should have given was to say, if you find that she lured him here, lured him there, but there was no intent to kill on her part, she's not guilty of premeditated murder. But if the direction had previously been given that in order to establish guilt, you have to show an intention to kill, Mr. Richardson's formulation is just saying the same thing, but the other way around.
Pretty much, sir.
That's your point.
And that's all my point is, sir. In respect of the hater point, sir.
Yes.
I wish to continue further. I just wanted to backtrack a bit that the section 31 application, we got the transcript, was it late last night or early this morning, from the section 31 application, and there was a decision of Sir Justice Greaves.
Yes.
I'm not sure if the court may have looked at it. It was a very short transcript of about 8 pages or less.
Speaking for myself, I have skim-read it.
Yes, sir. There was no reference to Cleveland Rogers' confession there, sir. And that, in a nutshell, is the case that was put forward against the appellant, Ms. Burgess. So it is in that context that when the former director, Mr. Mussin, then indicated in the severance application that we don't need to rely on hater plus. That's the context in which he was referring to, because there was sufficient evidence in our submission that the appellant Burgess could have been convicted without the need for the judge to give a direction along the line of hater. As to how we reach the actual directions that was given to the jury, I wish to go to the transcript of the discussion, read the law, and to pick up from where my Lord President had actually stopped.
Yes, which page?
Continue at page 25,
Mhm.
starting at line 8, where the court says, right, I have to say it's certainly not as clear in my mind in respect to Ms. Burgess as it is in respect of Mr. Rogers. It was obviously having, as Mr. Richardson, I think, put it, spent 2 days to get to the conclusion that the shoe print impressions could have or could not have been left by those boots or any number of other boots of the same or similar. Yes, so I think we are on fairly good ground in respect to Mr. Rogers. All right. Yes, sorry, anything else? Mr. Mahoney, I can't think of anything else other than the usual general stuff, explaining what it means acting in concert. I think those are the words in the indictment. The court, yeah, being concerned together, yes. In this case, effectively, what we are, Mr. Mahoney, it's really section 20, Mr. Richardson 727. That's why, because I wasn't clear in my mind whether I was going to deal with that when I dealt with the indictment or whether I was going to deal with it as a standalone in the general directions. But I think I'm probably more likely to deal with it when I go through the indictment, when I get to concern together. Yes, sir. You're going to have copies of the indictment and copies of the further and better particulars, which I note have now been signed. Mr. Mahoney, no, I would leave that to you, sir. Court, and while we are on the subject of being concerned with each other, and have the defense received copies of the signed further and better particulars in respect of Sir Richardson signed ones? No. Sir Daniels, no. Ms. Burgess, Mrs. King Dean, I'll forward it, court. Okay, so I think the particulars which were previously served on defense counsel have now been signed. I don't know if they have been filed with the court, but they are certainly before me. They just arrived. So we have had them previously. I don't think they have changed, but basically the indication is the Crown's case. And I guess this is the response to a request by defense counsel. Further particulars are that the defendant Katrina Burgess planned and carried out with her brother, defendant Cleveland Rogers, the offense of premeditated murder. The Crown contends that the defendant Burgess lured the deceased to the 10 Durrett Lane apartment for him to be killed by Rogers, knowing that Rogers was going to kill him. Therefore, she did not act or act for the purpose of enabling or aiding the commission of the offense, or aided the commission of the said offense. And then there's obviously a reference to 27(1)(a)(b) and or B and C, because that is, I guess, more directed towards Ms. Burgess. I have to say I'm struggling in the light of those particulars and the original indictment, notwithstanding your earlier indication, to see how, in those circumstances, I can leave Ms. Burgess to the jury if they conclude that Mr. Rogers is not guilty. Sir Richardson can't. Not in this case. They rise and fall together. I know that there are cases where I could quite happily turn around to a jury and say Mr. Rogers or some other person. But having framed the indictment and the particulars of the indictment the way you have, and then the further and better particulars the way you have, I'm struggling. I mean, to use the expression, nailing your colors to the mast. Mr. Mahoney, not necessarily, sir. There have been cases where they are tried together as per section 27, but one has to consider the evidence again, should be against each separately. So it's just like a joint trial. They can acquit one, convict the other, notwithstanding that the indictment alleged. The court, I'm not saying, Mr. Mahoney, that they were acting in concert. Right, I'm not saying that it can't be done. Yes, sir. Because the way that I initially started drafting the direction on 27(1)(a)(b)(c), and I even threw in D to start with until I appreciated what the Crown's position is, because I hadn't seen the further and better particulars. Yes, sir. Was the basis that Mr. Rogers or another, but I'm really struggling. Technically, yes, it can be done in cases. I'm just not sure that this is one of them. So Mahoney, well, sir, I can just tell you what our position is, sir. Right. And you may agree or disagree, because our case is whoever did the killing, she lured him there for him to be killed. So if the jury believes that it was not Mr. Rogers, it was somebody else, The fact is, she lured him there with the intention that whoever was there would kill him. Mr. Richardson, that's a whole different case. And the court, and I think I might, Mr. Mahoney, that's not a whole different case, sir. The court, I think I might be more sympathetic to your view if you hadn't drafted particulars of the case against Katrina Burgess in the way you did, because it would have been open to whoever drafted these particulars, and I don't know whether that would be yourself or the director's directions. It would have been open to you in those particulars to indicate for him to be killed by Rogers or some other person. Mr. Richardson, which would have really thrown things open on severance and everything else. So Mahoney, sir, it's up to you, sir. Once the defense position is clear on the record, that's fine, sir, because as I said, you know these things go if it goes elsewhere, and then counsel come and they take a different view. So I can only indicate to your position. The defense state theirs, and it's up to your lordship to make a final decision. The court, yeah, counsel, oh, sorry, there was one other matter. And court, it was just, yeah, Mr. Richardson, I thought you were inviting him on that point. I was going to, oh, okay, I'll leave that the court, and then I'll come back to you, yes. Mr. Richardson, I think that point been ventilated. The court, so what's your position in respect of what I should direct the jury in respect of Mr. Richardson aiding? No. In respect of Mr. Richardson, well, I take the view that the way the Crown have coached their case, in this case, there can be no other logical conclusion than that the only person she's aided is Mr. Rogers. And if he is acquitted and they find they are not satisfied she aided him, there is no other person on the evidence who she could aid. You can't just pull a straw man out of thin air. So this is a case in which that direction would have to be given, especially in light of the fact that you have this inadmissible, whether she paid him to do it. You're going to have to disentangle that to begin with. So yes, my lord, the short answer is yes, you're right. This is one of those cases, the court. So your position is that if they acquit Mr. Rogers, Mr. Richardson, they have to acquit her. If not, their verdict would be inconsistent. Mr. Mahoney, is the converse true? The court, sorry, Mr. Mahoney, sir, is the converse true? If they convict him, they must convict her. That was my next question, Mr. Richardson. If they convict him, they must convict her? No. Mr. Mahoney, there you go. Mr. Richardson, well, no. You have to analyze each case and apply it to the principle. If they convict him, they may have convicted him on that part of his confession which says he did it, full stop, because they can act on the part which says she paid him. So we can have that result, the court. They can act on the part that she paid him against her, against him, but not against her. Mr. Richardson, that's what I'm saying. The court, yeah. Mr. Richardson, that's my point. The court, because when I give a direction on motive, I'm going to have to give a direction in respect of motive against Mr. Rogers also, based on the money, because I think Katrina Carr's evidence was fairly clear. He saw the dollar signs. Mr. Richardson, it's the money. Ms. Mulligan, he was what? The court, she said something about Sir Richardson, he saw dollar signs. Mr. Daniels, he saw the dollar signs. Yeah, he saw a dollar sign. Ms. Mulligan, she also said she indiscernible. The court, right. So your position is the opposite, is not true. Mr. Richardson can't be true. So if Mr. Rogers, Mr. Richardson, you logically analyze it, my lord, I think you will, after you toss it around, you'll see exactly what we're saying. The court, I'm trying to. What's Mr. Rogers' counsel position on what Ms. Burgess' position would be? Mr. Daniels, on the first, no. I mean, while in a theoretical context, having as many different avenues would seem great for defense counsel quite properly, the way the particulars are set out, I just don't see how that argument could be supported. The Crown have effectively nailed their colors to the mast. The court, right, in respect of the position, if Mr. Rogers is acquitted, then it follows from that Ms. Burgess would have to be acquitted. What about Mr. Daniels, and insofar as the court, and what about the converse position? Mr. Daniels, I think I agree with Mr. Richardson in that regard, that respectfully, the way that the cases have been led, the evidence of payment is a motive part that they are putting on Mr. Rogers, but that is evidence only against Mr. Rogers. And I follow that narrative that you couldn't conversely switch, if that makes sense. The court, so if he is convicted, she could still be acquitted. Mr. Daniels, yes, yay. I see how that would work, because it depends on what the Crown, I mean the case that they have to answer. For Ms. Burgess, it is not a situation of having made payment, but for Mr. Rogers. Mr. Richardson, I raised this earlier. Mr. Daniel is right. It is and Mr. Richardson, I raised this earlier, my lord. I raised the issue of the basis upon which the jury are convicting. The court, So Richardson, are they convicted on the basis that he said he did it and he was paid, or would they convict simply on the basis that he said simply he did it? That's the problem. And they have to be directed in that as well. The basis upon which they convict. And since those two alternative bases exist and the Crown wouldn't give up one, then no, the converse can't be true. You can't do both. You either fish or cut bait, the court. So you're saying that he could be convicted on the basis of the payment, Mr. Richardson. He could be convicted on a basis of the payment and the fact that he said he did it, or he could be convicted simply on the basis that he said he did it, not for payment. I said that before. They could find on this evidence, and you said you couldn't see how, that he did it as some type of overprotective brother who was just coming to his sister's aid. That be the case, then the basis upon which he is convicted would make the so-called part of the confession that indicates payment totally irrelevant in the case against Ms. Burgess, the court. But it already is. I mean, they can't use her, Sir Richardson, yeah, I'm saying, but if that's the basis upon which the jury, if there's a danger they could convict on that basis, then we should have severed. So in order to cure that danger, you can't leave them that avenue. So here we are, the converse cannot be true. I hope everybody follows me. Mr. Mahoney, sir, I just don't want you to fall into error. The court, I don't want me to fall into error either. Mr. Mahoney, to bring up this issue about basis of conviction is either that he did it or he did it for payment. Because if you would deduce the latter, or the word is missing there. If you deduce the latter or even leave the latter in your submission, it's going to be a ground of appeal. Some only upon which they can be successful. The issue is, do you believe what he said that he did it? Yeah. Some only for whatever reasons he gave the court. Yeah, the only real importance of the direction in respect of that aspect of the confession is just to make it abundantly clear that there is no evidence against Ms. Burgess, Mr. Richardson. But that is why whatever he says is evidence against himself. So on what basis would they someone convict? He said he did it. The court convict Mr. Rogers, but not Ms. Burgess. Well, they may believe that she told him, yes, go and punch him up. And that's where Mr. Richardson read that with. Punch him up, but the guy went a bit too far. Mr. Richardson, really? That's speculation. I don't know. Mr. Richardson, that comes out of your mouth and jumping up on the top of the podium. So Mahoney, I don't know, but they didn't leave that evidence, so you can't leave that, sir. They can't leave that. Mr. Richardson, my learned friend, Mahoney, they could have gone that way, but they didn't, because she could have said, well, yeah, I had a chat with him. The court told him, go do him something, but I never, Mahoney, yes, just slap him up front, and the next thing he went and killing the guy. I never expect that. The court, yeah. Sir Richardson, that won't make her guilty of murder now, would it? We got a whole different set of directions to go with now. Mahoney, that's not the case, sir. Court, no, what we are saying is that that's not the way you went. Mr. Richardson, okay, Mr. Mahoney, right. So we don't have to go that way. Mr. Richardson, I think we have gone over a bit of this, sir. And moving on to page 41, line 1. Where the court says he's agreeing with your position, which is that they would convict Mr. Rogers and not convict Mr. Daniels. No, I am not. I am just processing. Mr. Mahoney. So there is that possibility, sir. They could agree with her case. So Richardson, let us not forget that the law restrains us, Mr. Mahoney. But anyway, I'm not arguing, sir. If they want to say, well, all or nothing, the court, all or nothing, Mr. Mahoney, fine. So Richardson, let us not forget that the law restrains my learned friend from leading any hypotheses to this jury that does not have some basis in the evidence. He can't just conjure up theories out of the thin air. And I pause there, sir, because Mr. Richardson would seek to want the judge to have left hypotheses to the jury in his summation in which there was no basis in the evidence or in law for him to have done so, sir. Continuing at line 21, the court know, but the suggestion that was just being made by Mr. Mahoney is that considering the cases separately, Mr. Richardson, they are bound by the hypotheses which are logically connected to those particulars. They can't speculate outside of that and think of different ways in which it could have been committed. The moment the court, so both defense counsel then are telling me that they rise or fall together. Mr. Mahoney, yes. Mr. Richardson, I'm not saying that. I've got my position clear that there is a scenario where he could be convicted and she's acquitted, but there is no scenario where he could be acquitted and she's convicted. That's my position, no matter how many ways we analyze it. Ms. Mulligan, might I chime in? I've been fairly good, quiet. The court, yep, you have been very good actually by your standards, I would say, Ms. Mulligan. Ms. Mulligan, just for clarity, in law, the court, Ms. Mulligan, I'm not saying he would be, but Mr. Rogers could be convicted on the basis that of his confession, that he went there and did it for money because either Ms. Burgess was being stalked or cheated on, depending on who you accept. Court, Ms. Mulligan, that evidence not being admissible against Ms. Burgess, I would have to agree that in law, as a matter of law, she could be acquitted on the case evidence against her, and Mr. Rogers could end up convicted on the evidence against him, that evidence. However, what I also further agree with is that it is not open to say to the jury at any point that they can speculate that he went there on his own lark, or that he was an overprotective brother who nobody involved in their lives had ever seen before. That he went there on spec, hoping to get paid. I don't know. Any of those theories aren't available. So there is only one theory, one position before the court upon which they could convict. It's not, as Mr. Mahoney says, it's for them to think that he went there for any other reason. But that is only the case against him. So I have to agree that even if the jury were to accept everything Ms. Card and Ms. Foley said, they wouldn't necessarily have to convict Ms. Burgess. That's a different case, because those conditions are not admissible against her. So, but I would hate to see the court saying, well, you may find the court, no, I'm not going to go off Ms. Mulligan, some other reason. No, right? That he went there and killed Mr. Richardson, that was a concern, yeah. So on that basis, if Mr. Rogers is acquitted, they would both have to be acquitted. Ms. Mulligan, yes. But Mr. Rogers could be convicted and Ms. Burgess acquitted. Mr. Richardson, yes. Are you finished, Mr. Mahoney? I am finished. My submission, sir, that is the background to how the case was left to the jury. It had nothing to do with haters, sir. It had more to do with how the further and better particulars were drafted in the case. And this was a case in which the instant case, the basis upon which the respective cases were left to the jury, was carefully drafted with the appellants involved in agreeing the terms of the directions to the jury, and the terms in which the jury was directed achieved a statute which precludes the appellants or appellants from now attempting to go behind it, sir.
Sorry, not quite following that.
In a nutshell, sir. Sorry.
No, don't put it in a nutshell for the moment. Are you saying that the council had in front of them a draft of what the judge was going to say?
No, sir. They agreed, we had the discussion, and there was an agreement as to how the judge was to leave the case to the jury in respect of if they convict Rogers, and one has to be mindful that Rogers was first on the indictment, so they would normally have to deal with him first. Because if Rogers was acquitted, therefore they would have to acquit Burgess based on all the further and better particulars were drafted, as well as the indictment.
Well, yes, that's the easy bit. Everybody agreed, and the judge directed that if Rogers wasn't convicted, Burgess could not be.
Yes, sir.
An awful lot of discussion about that, but it might be thought to be almost self-evident in any event, is what the judge said in the summing up. It was also accepted, and must be right, that the fact that Rogers was convicted did not necessarily mean that Miss Burgess should be convicted as well. And the summing up proceeds upon that basis also. There are two questions that have arisen. One is whether or not the judge adequately indicated or said that in order to convict Miss Burgess, they must be satisfied that she intended that Rogers should kill the victim. And the summing up on that appears to be said to be defective because the judge didn't add, and if they weren't satisfied that she didn't intend that the victim should be killed, Miss Burgess couldn't be convicted. That's point number one. And point number two, which I had thought was being made, and I'm not absolutely sure whether it still is, was that the prosecution could only put the case upon the basis that they had adduced evidence, namely to the effect that there was an intentional killing by Burgess, and that Miss Rogers, by Rogers, and that Miss Burgess was an aider and abetter of that intentional killing. But the prosecution could only put that case, but that the judge ought to have indicated in relation to Miss Burgess that whereas that was the prosecution's case, there are a number of other possibilities as to what Miss Burgess intended, which were consistent with her not being guilty of premeditated murder, e.g. that Mr. Rogers had simply been sent there to rough him up.
May I address the latter first, sir?
Yes, please do.
Yes, sir. I think it's abundantly clear, sir, that from the discussion and that it was an all or nothing case that was put forward by Ms. Burgess. There was no basis upon which the trial judge could have left any alternative. Sorry, I think I had made submissions on this before, because in effect it would be to undermine the case that was being run by Ms. Burgess, especially when there was no evidence to support any such alternative perspective. In short, the judge would be inviting the jurors to speculate.
Yeah. Okay.
In respect of the first question, sir, which brings us back to the eighth point, sir, it is my submission that the direction was not, at first glance, it would appear that it may by itself appear to be a direction akin to hater. But it is my submission that that is not so, because the reasoning behind that particular direction was rooted in how the further and better particulars and the indictment was drafted tying both into the joint enterprise. It had nothing to do with hater at all. Without the transcript of the discussion of the law, on the face of it, one would have the impression that in substance it was a hater direction, but it was not, sir. And the point I'm making is that both appellants agreed that the respective case should be left as it was. And in
I'm sorry,
Sorry, sir.
I'm sorry, I'm now hopelessly lost. You say on the face of it, it was in substance a hater direction, but
No,
in
sir.
fact,
Not.
what?
Sorry, sir. Go ahead, sir. I thought you had stopped.
I thought you were saying it was not a hater direction, Mr. Mahoney.
No, I'm saying it's not. But I'm
Well,
saying
wait a
on
minute.
the face of it, it may, not that I agree with the court, but on the face of it, I understand why the court may say it was in substance a hater direction. But my submission is it was not, sir. And that's why I requested a transcript of the discussion on the law to show why is it the directions came out as it did. And it had nothing to do with hater.
Well, you say on the face of it, it might appear to have been a hater direction, but it was not. That is, in one sense, it's true, because the judge does not in turns say, if you have found Mr. Rogers to be guilty of murder, you can, when proceeding, when determining the case against Miss Burgess, proceed upon the footing that the victim was murdered by Rogers pre-intentionally. That would be a hater direction. He doesn't say that in terms, but the point that is made is that if he wasn't giving a hater direction, it was necessary to be very clear that they couldn't do what they could have done if he had been giving a hater direction. In other words, they couldn't simply proceed upon the basis that once they had decided that Rogers was guilty of murder, that established, as against Miss Burgess, that the victim had been murdered by Rogers.
I respectfully disagree, sir. I don't think there was a need for him to have gone any further, sir, because prior to the hater decision, directions were left are normally given in these type of cases along the line that the court actually did, sir. And
well,
sorry, sir.
Well, we get to this curious position. Pre-hater, you say directions like this were normally given. Hater makes clear that you can give a specific direction that if the jury has been satisfied that defendant number one is the murderer, they can use that as a building block to decide whether defendant number two is the aider and abettor. There's then a discussion in which everyone proceeds upon the basis, appears to proceed on the basis that hater is not going to be relied upon. There is then a summing up in which the hater direction is not given in terms, but that's, so it is said, the substance of what the summing up was. And you now say, well, that doesn't matter because even before hater, you could give a direction of this kind. Seems to be a terrible muddle as to whatever. And lastly, the judge only said that he had it in mind not to give a hater direction and that he might change his mind.
But he didn't, sir. He didn't give a hater direction. And what I note that actually in the grounds of appeal, there was actually no complaint about those directions because counsel actually agreed to those directions during the discussion based on the point that I indicated, where we were discussing about the basis of the case, further and better particulars put forward by the prosecution.
Well, wait a moment. Where in this long and slightly rambling discussion is it accepted that the jury could be directed that if they are satisfied that Mr. Rogers was the murderer, they could, when considering Miss Burgess, proceed upon the basis that he was, and the only question was whether or not she was aiding and abetting.
My lord, I have been saying repeatedly that no hater direction was given, and based on the direction given, the jury could not have interpreted that what the judge said in that manner, sir. That's all I'm saying, sir.
So the jury, reading the summing up, although you told us a moment ago on the face of it, it might appear to have a hater direction. You say the jury could not have understood from the summing up that if they were satisfied that Rogers was the murderer, they could, when considering the case of Miss Burgess, proceed upon the footing that that was established vis-a-vis her.
Well, sir, may I make one correction, sir? When I said on the face of it, I'm saying not on the face of it, sir, because this court, I think my Lord President, took the initial view when we were last dealing with this point some weeks ago, that it was synonymous to a hater direction. And I was saying that in the context of what the court had said, without the court seeing the context in which the directions came into being, the court may be led to believe that it was synonymous to a hater direction. I am not saying that it was synonymous, sir.
Whether it was synonymous with or the equivalent of a hater direction must depend upon the summation in accordance with its terms.
But the summation must be viewed in its entirety, sir.
That's true.
And the cumulative effect.
That's true. But not in the light of whatever discussion had taken place between counsel and the court beforehand.
Yes, sir. But in light of the discussion, sir, the directions now being complained of, and I noticed that not even at this point, well, I think Mr. Richardson may be attaching some weight to it now, but that was never an area of complaint. But until his lordship raising that point, that was never ever an area of complaint, because the agreed position was based on the further and better particulars. How the case was run is that you could not convict Miss Burgess unless Mr. Rogers was convicted. It had nothing to do with either. And it was all grounded in the further and better particulars that was put before the court.
Mm-hmm.
And the appellants did not interpret the directions as synonymous to a hater direction. Based on the discussion that we had prior to the summation.
Right.
And that is a reason why there was no objection or issue raised when the summation was done in respect of that point. And further, there was no issue raised as a ground of appeal in respect of that point. And I've looked through all the grounds of appeal, even the amended ground 9A. There is no complaint by the appellant that the judge, contrary to what he had promised, ended up giving a direction which is synonymous to hater.
So were the jury to understand from the summation that in considering the case against Miss Burgess, and as to whether or not she aided and abetted Mr. Rogers, they must disregard the evidence that Mr. Rogers had confessed to that, even though they had taken that evidence into account in determining whether Mr. Rogers was guilty?
Yes, sir. Well, throughout the summation and even throughout the trial, The jury was reminded repeatedly that the confessions had nothing to do with Ms. Burgess. It was evidence against the appellant Rogers and Rogers only.
Yeah. They were. Right. Okay.
I think those are my submissions on that point, unless I can assist the court on any other areas.
Not so far as I'm concerned, thank you.
My lords, may I just very quickly, the court proposed 2 questions to Mr. Mahoney. And one of those questions, the first question, I'm not sure if my learned friend actually answered, my Lord President. My Lord asked, did the judge adequately indicate that Ms. Burgess must have intended death and nothing less? I think we're having a bit of a muddle here. I keep hearing the phrase intentional killing or intentional death being used interchangeably with premeditation. An intentional death without pre-planning, or which didn't exist prior to the actual execution of the act, would be murder. Premeditated murder is something different, my lords. It requires further preparation and planning. Doesn't require much lead time, but there must be an intention formed before, and here's the distinction, and which exists at the time of the killing. An intentional killing, the intention exists at the time, but it is different from premeditation, that is not formed before the person actually embarks on the exercise. There's a difference, and I want their lordships to be very careful not to conflate the two. And that is what we say his lordship did not give the proper direction on. He did not adequately indicate that Ms. Burgess must have had the premeditation and how they could get there. So I just wanted to add that because I don't think my learned friend had actually addressed that when he replied to you.
Right. Just before we stop, you made an observation that Section 88 of PACE was irrelevant because Section 88 only applies if the accused has been convicted of an offence which is admissible to prove that he committed that offence admissible in criminal proceedings. And you say, well, of course, Burgess was never convicted. Rogers was never convicted until the jury pronounced their verdict. So they couldn't take that into account. They couldn't make use, couldn't be made of Section 88, whilst they were in the middle of considering what verdict to make in relation to both defendants. That might be thought to be a somewhat artificial approach, in that if they proceed against the first defendant and decide that he's guilty, isn't he, for all effective purposes, so far as they're concerned, convicted?
No, my lords, he wouldn't actually be convicted until a proper verdict is rendered and taken. And once that happens, and for instance, the example that comes readily to mind is the case I was involved in, a money laundering matter, where my client was the local connect, and he was tried after his foreign connect was convicted in the United Kingdom. And the Crown were allowed to pray into aid in the case against him in Bermuda, the fact that his co-defendant had been convicted. However, they weren't allowed to lead the underlying basis of the conviction, simply the fact that he was convicted in reliance on Section 88. And that's how that section works. It can't be used by the same fact-finding body to convict and then go on.
I thought you might say that.
Thank you.
Right. Well, I think that concludes all that we can do today. We shall obviously have to come back to this case in the light of what happens in relation to the questions of the jury, which may be a developing saga. but it's a developing saga of which you will obviously be informed, and about which we may require further assistance hereafter. Thank you very much. We'll retire.
Thank you.
Hello, Quayla, can you still hear me?